1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
I'd like to do two different things if it's possible, which is maybe stand up at the beginning. I've got to be the moderator for this group, so I'd like to stand up and introduce them. But then during the whatever hour we're going to be here, I'd like to sit down and sit through, because I've also got to talk about one of the cases. So could I just move this chair like around here and turn this to me, or is that not?
Yeah, there's some slack. The only thing I'll warn you about is that this is all the microphone cables.
Be careful with
Yes,
that.
do be careful. But yeah, you're welcome to, do what you care to. If you want, this is wireless. You can pick it up and hold it if you care to.
Yeah, if I were to start off over here, would that be okay? And then I could sit down once they start talking?
Oh yeah, that's fine.
I think that's what I'll do. I'd like to introduce the group standing up, but then I don't want to stand for the whole hour during discussion. So I think I'll move over here.
Have a stool somewhere. But yeah, that's fine. I'm not one of the event runners. I just take care of the AV. So you can do whatever you care to.
And is there any problem on the sound if do I have to get close to the microphone?
What I'll say is that I have ways of making you loud. If people are telling me that you're too quiet, I can make you loud. The rule of thumb is that you should try and be like the distance. You should try and be like this far away from the microphone. But they usually have things tuned pretty hot, so it's totally up to you.
If I were standing right here and talking.
As long as you're projecting and bringing the microphone so you've got the room to pick up. If you go next door and listen, like it's picking up the room noise, it's probably picking up us talking. So as long as you're more or less projecting to the room, it should pick it up.
Anywhere over here is safe with this microphone?
Yeah.
And obviously it's safe right there.
Yeah.
Okay.
One, two. One, two, 3, 4, 5, 6, 7, 8. That's good. The rest of these. One, two, 3, 4, 5, 6. That one's good. All right.
Hey, Rich. Rich. you go retrieve the rest of my panel? If you go out in the hall, would you retrieve the rest of my panel? We'll be ready.
Well, anyway, I gotta, I was looking at that.
That's more important. I saw them out there. Yeah. Tell them to head in here. Right. Sound an alarm out in the hall.
Think we left you in the lurch?
I was hoping to retrieve the rest of the panel rather than do this whole thing myself.
So are you? Do you have an order? Are you gonna do the order of the cases you mentioned in the email? Start with.
I think I'm going to start with Stephanus on Insanity, then you, then Malvo, and then I'm going to do Bridgegate.
Great.
I'm trying to decide what to do here. I think I'm going to stand and talk and then sit down.
Okay. Great.
So if we could, we're talking outside, if we can maybe give 10, 12 minutes a case or whatever. In other words, you can present yours, I may ask a question too, and then move on to the next.
Okay.
Stephanus thought it was better to move on and talk, leave some time at the end to talk, rather than stop
Oh, I
and talk
see.
about each case.
No, I think it's good to have a little bit of conversation while the iron's hot, right?
I sort of thought so too,
Yeah.
so I'm going to try to split the middle and do both.
Yeah.
And do
Yeah.
a little,
Well, especially because, I mean, his case and my case has some overlap, but then the others are so distinct. Yeah.
if you have something to say about sanity,
Okay.
do you want me to start or not? Okay.
And you can go to 9:55 and just at the end just say that the next house starts at 10:10.
10:10?
10:10.
Ah,
What's
okay.
your Malvo case? Which sitting you?
With the last argument of the October sitting.
I see.
Okay, good.
We got the first argument in the October.
I'm not going to worry as much about
Have you ever been in an afternoon?
finishing at 9:55.
So that's not. What does one do? I'm really confused.
No, so literally I have exactly the same question. So my solution actually will not help.
Okay, okay.
But what my solution was, I'm staying on West Coast time. And so because I had exactly the same question, I was like,
My whole rhythm of the day.
I just woke up. I woke up at 10:30. Just had the same day.
But you went over. So, for example, you didn't. I mean, I think I'm not going to watch the morning arguments, right?
I didn't.
Get
the time
dressed
I
up
did
and
it.
sit there for like 2 hours.
Well, what's funny is I didn't the other time. This time I'm thinking I might because I'm kind of frustrated with the court. I don't know if you noticed this, but the case you're about to talk about in Rainbows are both scheduled for the same day. But they have the Kansas case at 10 a.m.
Morning.
My case at 1 p.m. I kind of want to see the Kansas case. And they have a patent case in between.
Oh, boy.
So why they didn't put my case at 11?
The two criminal cases together.
Yeah, they both have the historical.
Right.
And I kind of want to see that argument just to get a sense of their reaction to.
It'd be a long day if we made it to this.
So I really don't know what to do. I don't know whether I'm going to go over early and have exactly the problem you're describing.
Too much nervous energy for too long ends up being exhausted.
I don't know what. Yeah, I mean, it's not like you're doing anything productive in the morning, other than just getting revved
Go
up.
to the 10 a.m. and slip out for
I might do that.
There's no reason to go to the patent case.
Right.
None
I
at
might
all.
do something like that. Yeah. It's a nice day. Just take a walk. Yeah.
And unlike what Kurt was telling us this lesson about when Berger was chief, that he would sometimes just decide to go straight into the afternoon case. But I gather under the new regime, the afternoon case is at 1 o'clock. It does not matter what time the early ones are.
I will double check that too. I mean,
They
but I'm
have
pretty
a
sure
lunch
that's what they do.
at noon.
Well, no, the guide to council literally says you don't even have to show up until 12,
Okay.
like 12 or 12:15.
Yeah, but I've heard that about the old days. Is that like if one of the cases went short, they would start the third argument at 11:55 and get 5 minutes in, and then go have lunch, and then come back. Can you imagine? It's just crazy.
We're about ready?
I know it does sound awful. Although I guess if somebody asks you a hard question before lunch, you can give
And 3, 2, 1, noon. Okay, let's come back.
Yeah, I'll get to that in a minute. The other thing I remember about it is that it's
Hey, Neil?
they basically just walk in the room,
Neil.
sit down, and the gavel goes down, and you're at the podium.
Oh,
Like
interesting.
there's no, you don't get the oyez,
Oh,
oyez.
oh, wow.
You don't get the.
You ready to go?
You don't get the bar admissions. You don't
Right,
get
right,
that,
right.
You don't get
The
that
ease into
3
it.
or 4 minutes of kind of
Ease in.
gathering yourself.
Good morning.
So are you, what are you talking
Good morning. We're here to talk about criminal law, and I don't want to impose any penalties for talking or being late for class, but so we're going to talk about crime, punishment, and the Roberts Court. Compared to some of the other topics we're going to talk about later today, I think criminal law is sort of interesting, and it's not quite as ideological. The ideological divide is not as clear there as in other areas. Back in the 60s and 70s, crime really was the issue that divided the court. In the 80s and 90s under Rehnquist, there was still very much of a liberal-conservative neat split. I think in the late 90s, Justice Scalia in a number of areas on the confrontation clause and juries and search cases would sometimes take the position with the liberal side, and just as often Justice Breyer would join the conservatives. And with 2 years in with Neil Gorsuch, he's a very conservative guy on a lot of issues, but not necessarily on criminal law. There's a fair number of cases where he's been on the liberal side. So I think it makes criminal law sort of a little less predictable and I think a little more interesting. We've got 4 issues we're going to talk about. The insanity defense and whether it's a constitutional requirement. The old question about whether a unanimous jury verdict is a constitutional requirement. A case about juvenile killers and whether they can be sentenced or must be sentenced to life in prison without parole. And then a case about when a political scandal can be charged as a federal crime. And we have an excellent panel to talk about these issues. Toby Heitens is the Solicitor General for the state of Virginia. Jeff Fisher, I think you all know, as a Stanford law professor, and I would say the most effective, most successful advocate for criminal defendants in the Supreme Court for about the last 15 years. And Stephanus Bibas, who was a longtime Penn law professor and since 2017, a judge on the Third Circuit Court of Appeals, and we're delighted to have him here at the William and Mary Conference. Why don't we begin with insanity? Stephanus, tell us about the case of Collar versus Kansas.
So, I'm the insane one? All right, thank you, David, and you've touched on a few themes. We'll come back to what connects the cases generally afterwards, but Collar versus Kansas is going to be argued at the very beginning of the term, beginning of October. The question presented is whether the 8th and 14th Amendments permit a state to abolish the insanity defense. Some issues about whether the 8th Amendment is fully preserved here, but let's just assume that the court can get to both of them. At common law, there have been a bunch of different tests for insanity. Anyone who's taught criminal law knows. There's this classic McNaughton test from 1843 that focuses on whether the defendant knew the nature and quality of his act or knew right from wrong. There was a volitional component of whether someone could control an irresistible impulse. There was briefly this, is it the product of a mental disease or defect test? There are lots of variations and flavors floating around. And they've developed many of them over the last century and a half. So how much of this is constitutional? The court had a series of cases. It had, Powell versus Alabama. It had, another one from Nevada, and it had Clark versus Arizona. And in each of them, it said, no, the irresistible impulse is not constitutionally required. This particular formulation isn't required. In Clark, it said, well, McNaughton, this 1843 case, I guess, from England, the whole of it is not required. You don't have to understand what you're doing as long as you can, in that case, the law in Arizona preserved the defense if you don't know right from wrong. Now, the question here is whether a state can get rid of even that and just say, you can use insanity to show that you lack mens rea, the guilty mind, the mental element of a crime. But is that constitutionally required or not? So Kansas and 3 other states don't have any insanity defense beyond mens rea. Alaska has an unusual one that has an insanity defense, but it does not allow you to argue that you knew right from wrong. So this is going to affect potentially the law in 5 states. And the Solicitor General of the U.S., interestingly, has come in on the side of the state saying we don't currently have a defense that narrow, but the federal government has an interest in potentially the flexibility to do so in the future. So it wasn't immediately clear what the federal interest was, but that's how they've articulated it. The petitioner here, Craig Collar, had a troubled marriage, was estranged from his wife over allegations of infidelity, and then after at the end of one Thanksgiving celebration at her mother's house, he broke in, he shot his wife, her mother, his 2 daughters, let his son go. And it was a brutal killing. There is some evidence that he committed the homicides in a dissociative state. The parties argue somewhat about what was in the record. Collar argues, the striking thing about these briefs that I think tells us a lot about where this court is and how different it was from 30 years ago, these briefs are fundamentally historical. Right? The frame of both of them is, here's how the law has developed, sometimes from the dawn of time. I mean, petitioner's brief starts at Genesis 2 and 3. And Adam and Eve's in the Garden of Eden about the knowledge of good and evil. That's how historical the briefing is. So petitioner is in Genesis, Talmud, Plato, Jesus, Justinian's Code, Islamic law, and then especially getting down to the nitty-gritty in English common law. From the evidence is that by the 14th century, according to Collar, insanity in the sense of not being able to know right from wrong was a complete defense to criminal charges. At the founding, Collar argues the common law did not allow for punishing the insane. And that, by the way, that is not contested here. There's a settled doctrine in the Supreme Court that you can't execute the insane. This is an issue about whether you can convict the insane without allowing this defense at the time, based on the mental state at the time of the crime, not at the time of the punishment. So at the founding, Collar argues the common law didn't allow for punishing the insane, and that was connected to this idea that it would have been cruel and unusual to do so. As McNaughton was decided in 1843, he argues that by then, the ratification of the 14th Amendment, 3 decades after that, what codified it, so there's no doubt that the right and wrong notion of insanity as a defense to criminal culpability was absolute. So this also gets into what incorporation means, and does it have to have been ensconced at the time of the 18th century in the Bill of Rights or in the mid-19th century. So Collar argues the right to raise an insanity defense is protected under an originalist understanding of the 8th and 14th Amendments. Now Kansas comes back with a historical brief of its own. It argues it does not in fact abolish the insanity defense, since it still lets evidence of insanity negate mens rea. It claims that it just has one of multiple permissible approaches to insanity. It says its approach has a common law provenance. So when it goes back through the history here, it says these historical sources, especially the common law 14th century on, they're about whether someone intended a crime. And so these references to good and evil are really references to whether someone had the mens rea for the crime or not. And it says it's right and wrong, that the right and wrong version from McNaughton is an invention of the 19th century. Remember, McNaughton's 1843. We can question what to do about that given incorporation in the 14th Amendment. So the parties hotly contest which version of the insanity defense has originalist bona fides. They also argue about whether a more modern approach to the 8th Amendment, assuming that an issue is preserved, requires a right and wrong insanity offense. Collar says punishing those who can't tell right from wrong doesn't serve retribution, deterrence, incapacitation, or rehabilitation, the 4 traditional justifications of punishment. Kansas disagrees, as does the U.S. Solicitor General. Kansas also claims that its mens rea approach might be more humane. It does less to stigmatize the mentally ill. It argues there's no reason that defendants who commit crimes due to mental defects that blind their sense of right and wrong should be any different from terrorists who commit crimes because their religious and political agendas tell them that they think the acts of violence are right or wrong or justified. More fundamentally, the Kansas resists the notion that the 8th Amendment can be used to dictate not just what modes of punishment are acceptable, but whom states can punish. It says legislatures can best determine who's blameworthy. Collar says the Supreme Court's decision in Robinson in 1962 says the 8th Amendment restricts whom the states can decide to punish. So the court has to grapple with the historical evidence. The parties are disputing what was true in 1791, what was true in 1868, and Collar has to explain why this version of the insanity defense is codified among others. If I can just frame this a little in terms of the broader criminal law, I think that one of the real challenges here, as in many cases, like Apprendi, is what do we do with a criminal justice system that looks different from a criminal justice system that looked historically? In Apprendi, part of the problem was there was no sentencing phase at the time of the founding, and juries were doing some sentencing. Analogously here, at the time of the founding, blameworthiness and right and wrong were jury determinations. And by the way, everyone got a jury, unlike today, where most cases are plea bargained. And so we had these mens rea terms, but mens rea common law, it's hard to get around. It's certainly hard to squeeze it down into little terms. Back at common law, a lot of the terms involved the idea of wickedness or wrongfulness, but was that understood in quite the way we mean moral wrongfulness? And yet most states today have moved mens rea towards this very clinical model penal code approach that's much more about could you know what was going to happen down the road if you did this in a very cognitive way, not necessarily an affective or emotional way. And so we have a changed legal landscape, we have a changed concept of mens rea in courts, and what's the court going to do with originalist evidence, conflicting originalist evidence, and superimposing that on a system that both has different ways of attributing blame and different concepts into which we're trying to shoehorn it?
May I ask a question about how, I was puzzled reading the briefs about how Kansas, suppose a guy goes down to Kansas City street today, carries a gun, shoots 3 people, somebody says, you've killed 3 people on the sidewalk, and the guy says, yeah, I know, they were Martians. They were Martians and they needed to be killed. He deliberately killed the people, but let's say we're really convinced the guy thought they were Martians. What does Kansas do with that person?
Well, it depends. If he thinks the Martians are not humans, I mean, the classic is, under McNaughton, if you think you're squeezing a lemon and not squeezing your wife's neck, you're not aware that you are killing a human being. Now, if he thinks that the person, it's in fact a human being, but this person was sent by the Martians or taken over by the Martians to invade, then you realize you're killing a human being, and so the mens rea defense wouldn't operate. But it depends on whether you're aware it's a human being. So if yes, fine, but there are other classic insanity conundra that we teach in first-year criminal law. Well, what if you hear voices that you think God is telling you to kill? Right? There's this deific command doctrine in a lot of states. And if you know that you are killing a person, usually that's not enough, even though there are a lot of mental illnesses where hearing voices is a symptom in DSM-3 or DSM-4. And it's not clear that Kansas doctrine would allow that. But Kansas does make a point in its brief, which is the most we're saying is we want to hold this person liable. Our law actually gives a lot of flexibility at sentencing, right? Now, it's a little ironic here because Collar himself got the death sentence, but he did have the opportunity, they stress, to introduce a bunch of evidence and didn't, and the state draws an inference that he couldn't, even though there was plenty of ability to address it at the sentencing phase. So the question is, should this go to the ascription of guilt and blame in the first place, or just the degree of blame and punishment?
Jeff, did you want to say anything on that?
Oh, well, my answer, having grown up in Kansas City, my first answer would be Kansas wouldn't have jurisdiction because that crime would have occurred in Missouri.
Isn't part of the city in Kansas?
There is a Kansas City, Kansas, but not the Kansas, anyway. Sorry. But I think more seriously, I mean, one thing that picks up on your initial comments about the court as it views criminal law right now is there was a dissent from denial of cert about 5 years ago on this issue from Idaho, one of the other states, where Justices Ginsburg, Breyer, and Sotomayor said they would have taken the case, and Justice Kagan seemingly departed from her allies. And so one thing people took from that was maybe Justice Kagan didn't think the votes were there to do what the people who wanted to grant the case wanted to do. And it just brings us back to your point about Justice Gorsuch being
She was waiting for the arrival of Neil Gorsuch.
Maybe. I mean, it's just an interesting thing to watch and how they'll approach the historical arguments in this case.
Okay. So shall we move on to Ramos versus Louisiana and juries?
Sure, I'd be happy to. But before I do, I just want to say thanks again for including me in the conference. It's something that's on my calendar every year as just a wonderful weekend, and so thanks for having me be part of this. So I'll give the spiel on Ramos versus Louisiana. I guess the first thing I should say is I'm representing Mr. Ramos, and he pronounces his name Ramos. And so lest you think that I can't pronounce my client's own name, that's how he pronounces his name. This case is, as you said, about whether there's a Sixth Amendment right that applies to the states to a unanimous jury verdict in criminal cases. And I sometimes, this issue's been around for a while, as you said, and I've sometimes thought this is kind of like a trivia question. What do Louisiana and Oregon have in common? And the answer for many years has been they're the only two states that allow criminal convictions by non-unanimous verdicts. Interestingly, each through their own story. Louisiana's provision dates back to 1898 as part of its constitutional convention that helped usher in the Jim Crow era and adopted the grandfather clause, among other infamous provisions that were designed, to quote the sponsor of the convention, to assure the supremacy of the white race in Louisiana. Oregon's provision dates to 1934. And the evidence there shows that it was sort of a result of anti-Semitism. There were a couple of verdicts that were 11-1 where Jewish defendants were acquitted, and there was a great deal of public outcry that led to a popular initiative in the state. And so those are the only two states that have ever done this, and so those are their two individual histories. In 1972, the court actually looked at this issue in a case called Apodaca versus Oregon, and upheld, or you would say, upheld the state's rights to have these laws, but in a very splintered set of opinions.
The court divided 4-1-4, with 4 justices saying that the way they would approach the question would just be a pure Sixth Amendment question of whether the right to the jury trial, as it is understood and meaningful today in contemporary society, requires today being 1972, requires a unanimous verdict, and 4 justices would have said, no, it doesn't. 4 other justices would have said the history of the Sixth Amendment, which I'll say more about in a moment, but the history of the jury trial right has always demanded unanimity, and they would therefore follow that history and apply it to the states and the incorporation doctrine. Justice Powell broke the tie, cast a vote in the middle. He said, I agree with the dissenters that the Sixth Amendment requires a unanimous verdict, but I would not apply that particular component of the Sixth Amendment to the states. And so that has sat there over the years, and in the past decade or so, the court has had two incorporation cases, one McDonald versus City of Chicago involving the Second Amendment, and then last term, Timms versus Indiana dealing with the excessive fines clause of the Eighth Amendment. And the court has dropped 2 sort of uncomfortable footnotes in those cases saying, the only deviation from our practice now, which is well settled, that any constitutional right that we recognize has to apply the same way to the states as the federal government is Apodaca. And so shortly after the Timms opinion came out with a footnote like that, the court finally granted cert to reconsider Apodaca. So to pick up on a panel last night talking about stare decisis, this is one of those cases where the question presented is, should we overrule a past case? So let me tell you a little bit about what the arguments are, and then maybe my fellow panelists want to say a word as well. So Mr. Ramos, just to put the facts on the table quickly, was convicted of second-degree murder in Louisiana by a 10-2 jury verdict. And so the question, is, as I said, is whether that violated the Constitution. We are the petitioner. In our opening brief in the case, we basically start, as the court started in Apodaca, by recognizing there's really 2 pieces to this case. The first is what the Sixth Amendment requires, and the second is whether the 14th Amendment requires the Sixth Amendment to apply equally to the states. And so we start in the Sixth Amendment from a standpoint of precedent. We remind the court that 5 justices in Apodaca said that the Sixth Amendment requires unanimous verdict, and we count up 14 other Supreme Court opinions, both before and after Apodaca, where the court has said, sometimes in passing and sometimes more substantively, that the Sixth Amendment requires a unanimous verdict. And we say, that precedent and those prior statements are correct because if you look at the common law, which is how the court has told us, particularly in recent years, we should construe the right to jury trial as codifying the common law, you can go back to 1367. Now, I recognize in light of what you just heard about Genesis that seems like, I guess, like a lousy historical argument at this point. But we thought 600 years of common law was worth a little bit. So nobody disputes that the common law did require a unanimous verdict. And so we say that's what the framers would have intended to codify in the Sixth Amendment. As for incorporation, we simply say Justice Powell's theory of partial incorporation was actually illegitimate when he announced it and has been fully renounced by the court since. And so stare decisis really has very little to say in this case because in terms of the 14th Amendment, because of the splintered nature of the opinion and the fact that his vote is now just an utter outlier without any support in the court's case law. The state comes back in its brief and actually makes one interesting strategic move. I kind of think of it as going double or nothing. The state has not made a 14th Amendment argument in support of Justice Powell's partial incorporation theory. They've put all their chips on the Sixth Amendment side. So the state is now arguing, just as a pure question of Sixth Amendment law, that the Sixth Amendment does not require a unanimous verdict and that the 4 justices in Apodaca that took that view were correct. The state doesn't dispute, as I said, that the common law history required unanimous verdict, but the state does dispute that the framers intended to codify that common law aspect of the right. And I think the strongest evidence the state points to in that respect is an early draft of the Sixth Amendment, which was more detailed and said that the right to jury trial should be preserved, including the right to unanimous verdict and other details. And in the editing process, those extra language was taken out of the draft. And so that is principally what the state points to as evidence that the framers must not have intended to codify that aspect of the right because they didn't include it. We come back and say, well, there are a lot of state constitutions at the time that didn't include it, and everybody understood it still included that common law aspect, but there's a debate there about the history. So I think what's interesting then is it leaves us in a curious place in terms of stare decisis, where the court took the case, as I said, I think, you could view it as one where we as the petitioner had to overcome stare decisis, or at least explain ourselves on the terms of stare decisis. But now, as the case has been briefed, the state is not even defending the pivotal vote and opinion in Apodaca, and the state is the one telling the court to disavow what 5 justices said in Apodaca and what the court has said 14 times in other opinions. So as the court has this much larger conversation going on about stare decisis, it'll be particularly interesting, I think, to see how they approach this case in that respect.
Let me ask one small question. I would say this is one, Jeff, where the odds are in your favor, I'd say, 48-2, and it sure looks like they wouldn't have taken this case unless, what happens, assume you win, what happens to all the people who, in the past, who've been tried and convicted in those states? Do they get a new trial, or would it be only for future
Well,
jury?
there's a set of questions, and I'm glad you asked that, because it's one other important thing about the state's briefing that's interesting is even though the state does not defend Justice Powell's 14th Amendment holding in Apodaca, the state does say we have a reliance interest in those past convictions that the court ought not upset. And the state of Oregon filed a brief basically saying the same thing. So we have a set of, for people who know retroactivity law, and we'll get to it more in a moment, we have basically some different categories of defendants. We have the easy category are the defendants on direct review. Those defendants, at least if they've preserved the issue, would certainly get the benefit of a decision from the court. But that's as far as we can say with any degree of certainty, because this issue has been around so long, and because so many defendants in these states really thought the court's never going to take up Apodaca again, you have a bunch of people who didn't even preserve an objection to non-unanimous verdicts, or even cases where you're not even sure what the verdict was because the jury wasn't required to there was not a poll that was requested. So you have problems of record and preservation in some cases, and then you have problems of retroactivity potentially, where arguments are going to be made, first of all, about whether a decision like this would be a watershed rule that would be retroactive to defendants whose convictions have become final. The court has never found a new rule of criminal procedure to be a watershed rule, but there would be arguments in that respect, I think, perhaps for this. And then you also have arguments about whether the structural, whether this would be structural error as opposed to subject to harmless error. So I think it's fair to say there would be litigation if we win, but it's really difficult to say what the court or even the state courts would do with it.
And you don't think the court will give us any guidance on that point today? In other words, the decision won't say much one way or the other about what to do about past cases?
Typically, the court's practice is to just decide the constitutional question and let questions about retroactivity and post-conviction relief follow, as they do in Toby's case.
Well, that sounds like a good segue to move on to Toby's case.
Okay. So I'm realizing this is a sign of advancing age that I'm going to have to give a little background for at least the students in the room. And the background is that 2000 to 2001 was an absolutely bonkers time to be living in our nation's capital. Because we started in September of 2011 with the terrorist attacks that, among other things, 2001, that involved the Pentagon and the World Trade Center in New York. A week later, there was a bunch of anthrax mailed to various people in Washington, D.C. And then just when people thought things were calming down, 1 year later, in September and October of 2002, there was a string of seemingly random shootings throughout the national capital area. Where you had situations where people were like pumping gas or at a Home Depot being shot by an unknown individual with a high-powered rifle. It eventually, after a sort of significant investigation, was revealed that there were two shooters. One was a 41-year-old man named John Muhammad, and the other was a then 17-year-old man named Lee Malvo. So Muhammad drops out of this story pretty quickly. He was convicted in pretty short order, sentenced to death, and was actually one of the last people executed in Virginia without, I guess, a lot of legal controversy. So this case involves the 17-year-old offender, Lee Malvo. He was actually, the prosecution sought the death penalty against him because under then existing Eighth Amendment law, you could still get the death penalty as a juvenile offender, but the jury did not sentence him to death. Instead, he was sentenced to life without parole. He then pled guilty to a number of other crimes for which he was also sentenced to life without parole, and that was in 2004. But meanwhile, the Supreme Court is sort of still moving along while this is all happening. So Malvo is sentenced in 2004. And then in 2005, the U.S. Supreme Court begins a series of cases involving the Eighth Amendment restrictions on penalties for juvenile offenders. So in 2005, the Supreme Court holds that the death penalty for juvenile offenders violates the Eighth Amendment. So even if Malvo had gotten the death penalty, that would have been vacated because of this decision called Roper in 2005. Then in 2010, in a case called Graham, the Supreme Court says that you cannot sentence a juvenile offender to life without parole if that offender did not commit a homicide offense. That doesn't directly help Malvo, though, because he committed a large number of homicide offenses. But then in 2012, the court decides the first of the two cases that really takes center stage in this case, called Miller versus Alabama. And Miller versus Alabama, at minimum, well, you're going to see one of the debates in this case is what Miller versus Alabama said. But everybody agrees that at minimum, Miller versus Alabama says is that you cannot have a mandatory life without parole sentence for a juvenile offender. Yes, and in the interest of similar to Jeff's point, I represent the petitioner in this case, so factor that into your assessment of how I describe this case. But I think everybody agrees that at minimum, Miller says you can't sentence a juvenile offender mandatorily to life without parole. So having Miller decided in 2012, Malvo then files a petition for habeas corpus, federal habeas corpus, in 2013, seeking relief under Miller versus Alabama, the then recent decision in Miller versus Alabama. And per something Jeff was just talking about, he originally loses in the district court. The district court says, your conviction is long since final, and there's no indication that Miller versus Alabama is retroactive, so I'm denying habeas relief on the grounds that you're not eligible for relief under Miller versus Alabama. Malvo then goes up to the Fourth Circuit. The case gets delayed for a while, and while the case is before the Fourth Circuit, the Supreme Court decides the second case that's important in this case, and that's a case called Montgomery versus Louisiana, where the question presented is Miller versus Alabama retroactive to cases that were pending on collateral review? And by a 6-3 vote, the Supreme Court says that it is. So now, again, the district court having ruled against Malvo on the theory that Miller was not retroactive, the Fourth Circuit sends it back to the district court to say, well, that's not going to work anymore because the Supreme Court has now said Miller is retroactive. And so that's when the sort of dispute that's now before the court sort of starts to take shape, where the dispute in a nutshell between, I'd say, the state and Malvo is, what is the holding of Miller, what is the holding of Montgomery, and how do the holdings of Miller and Montgomery fit together? So the state's argument, in a nutshell, is Miller's holding is expressly limited to mandatory life without parole sentences. The Supreme Court of Virginia has held that Virginia's sentencing scheme is not, in fact, mandatory. Therefore, he's not entitled to relief under the Miller rule, which was made retroactive in Montgomery. Now, Malvo's argument is a little different. He sort of argues two different things at the district court. First, he says, no, in fact, Virginia's scheme is, in fact, mandatory. So that is sort of taking issue with the state's argument on the terms of the state's argument. But he has a second argument, and the second argument is that in the course of holding that Miller was retroactive, Montgomery was required to consider and expound on the nature of the Miller rule. And given what the court said in Montgomery, it is now clear that the Miller rule reaches beyond mandatory sentences as well. So regardless of whether his sentence is mandatory or not, he got a life without parole sentence, and he didn't get what Montgomery holds that he's entitled to. So the way the district court resolves this is the same way the Fourth Circuit ends up resolving it, saying, oh gosh, the question of whether Virginia's scheme is mandatory or not is really hard, and probably as a federal judge, I feel deeply uncomfortable wading into the particulars of how Virginia's sentencing scheme works, so I am not going to decide that because that looks tricky. So I will assume for the sake of argument that Virginia's scheme is not mandatory. And then the district court agrees with Malvo that regardless of whether it's mandatory, the rule as explained in Montgomery applies to Malvo's case. Goes up to the Fourth Circuit. The Fourth Circuit says exactly the same thing. We are not going to wade into whether Virginia's scheme is or is not mandatory, but we're going to hold that as clarified in Montgomery, Malvo is entitled to relief. So the state, my client, seeks cert, and then the and we wait. and we wait, and we wait, and we wait. In fact, by my count, the Supreme Court relisted this case 8 times. Before finally deciding whether to grant or deny. Fun fact, among friends and, in the privacy of this room, which I know will never be recorded, I was absolutely convinced they were denying cert. And I was absolutely convinced that they were waiting, that all we were waiting for was a dissent from denial, and the only interesting question is whether it was by Justice Thomas, Justice Alito, or Justice Gorsuch. And I was expecting a lengthy recounting of all of the crimes and how it's outrageous that the court has denied cert in this case. That was what I was utterly convinced what was happening right up until the moment that they granted cert. And so now the case is basically before the court, and we're basically having the same arguments. I think the only sort of real developments in the briefs is the briefs really are not engaging in the question of whether Virginia's scheme is mandatory or not. I think both sides have probably concluded that the U.S. Supreme Court has very little interest in deciding a question, A, that was not decided by the courts below, and B, seems like a tricky, difficult question of state law. And so the issue really, it really depends, right? So from the state's perspective, the question presented is, what is the holding of Miller versus Alabama? And from Malveau's perspective, he responds partly on that, because there is some language he relies on in Miller that he says supports the rule that he has. But it's also relying on what the court said about Miller in Montgomery. Now, the elephant in the room in this entire case, right, is the retirement of Justice Kennedy and the replacement of Justice Kennedy by Justice Kavanaugh, because Justice Kennedy wrote Montgomery versus Louisiana, the second of the 2 decisions. The first one is written by Justice Kagan. The second one is written by Justice Kennedy. And I think at minimum, one can say the following, and I think this would be an uncontroversial statement if Malveau's lawyer was here as well. Those 2 opinions are very different opinions, and the way they think about the issue, the way they discuss the issue, the way the breadth or the narrowness of their language, they are very, very different in terms of how those 2 opinions are written. I think that should be a relatively uncontroversial statement. And we can talk about why that is, but in many ways the question, and I think one of the things the parties are really struggling with over, because it's something that people talked about last night, the position of the Chief Justice as the sort of new ideological center of the court. I think the strategy of Mr. Malveaux is to say that the state is essentially asking you to overrule Montgomery, and you shouldn't do that, Mr. Chief Justice, because you want to be careful about the number of times you're overruling cases. And for the state's part, our position is this is just a straightforward application of Miller versus Alabama. And there's no one's overruling anything. Don't worry, don't panic, it's fine. And I really think it is overwhelmingly likely that the Chief Justice is by far the most important vote in this case. It's entirely likely that he may be the only vote that's important or seriously in play in this case. It's going to be argued the last day of the October sitting, October 16th.
So the bottom line is what's at stake here is whether Malveaux will ever have a parole hearing at some time in his life. Is that, if you lose, he will at some point have a parole hearing?
He will at some point have a parole hearing on his Virginia homicide charges. One of the things that's lurking in the background is, at least by the facts that are recounted, he committed or attempted to commit 12 homicides in the DC area in about a 2-month period. So one of the things that makes the case a little interesting, and there's some articles about this even by some of his own lawyers, it seems extraordinarily unlikely that this individual is ever getting out of jail under any circumstances, because even if he were to win this case and even if he were to get parole on this offense, he also has life without parole sentences in Maryland, and he also probably has 7 or 8 homicides for which he was never prosecuted that he could now be prosecuted. But yes,
Yeah.
the question is whether he gets a
So
parole
it's
hearing.
not exactly home free.
No.
If he, well, so let's move on to the 4th case. The issue is, we have portrayed it as whether a political scandal can be prosecuted as a federal crime. This is the case of Bridget Kelly versus the United States. It's about the Bridgegate situation in New Jersey. This case seems like a setup for New Jersey jokes, but I'm not going to stoop to that sort of thing. In fact, some of the briefs make, I think, a really interesting big picture point, is that we're in a very polarized political climate when political rallies say, lock her up. And, if I watch MSNBC in the evening, surely they will have a segment talking about various people who are in the Trump orbit who are under investigation and seem to be criminals and perhaps should be prosecuted. And then if I switch to Fox, they will have a segment on a series of people who are investigating the Trump people, and they seem like criminals, and they should be prosecuted. And from what I take from it is that we should be very careful about the use of the criminal law and branding people as criminals in a very polarized time. So you probably know the basic facts of this case. Governor Christie was running for re-election in 2013. His campaign staff wanted to get various people to endorse him around New Jersey. They tried some nice things, like in Fort Lee. They spent $300,000 on free shuttle buses. That didn't work. And so the campaign did what used to be, the phrase was, they decided to go negative. And they changed the 12-lane bridges. There had been 3 lanes that were for traffic coming up from New Jersey onto the bridge. They announced they were going to do a traffic study, and they closed off 2 of those lanes, so there was only 1 lane, and it predictably backed up traffic in Fort Lee. This went on for a week. It was a big ruckus. Some various people, including David Wildstein, who seemed to have been the mastermind of this project, and a fellow named Bill Baroni, who worked for the Port Authority, and Bridget Kelly were fired. They lost their jobs. Wildstein agreed to cooperate, and about a year later, Bridget Kelly and Baroni were charged, indicted for fraud, wire fraud, obtaining government property, tried, convicted, and the Third Circuit, not on a panel with Judge Bibas, but upheld the convictions. And do you know what the crime, how it was portrayed? Is that, fraud is essentially using a lie or deceit to obtain money or property. In this case, it was something to do with the bridge and the Port Authority. In other words, Bridget Kelly didn't get any money in her pocket. The theory of the case was that they used deception, and there's a line in the brief that I couldn't, I was sort of amused by. It says, Wildstein testified that they sat around in the office, the co-conspirators, and, quote, found it humorous that the Port Authority would have to pay a second toll collector to sit and wait in case the first toll collector had to go to the bathroom. Then it says, payroll records established that 11 overtime toll workers were paid a total of $3,696.09. Now, the reason that's important is that turns out that's the money. That this deceptive scheme required the misuse and misspending of $3,609 for overtime paid to state toll collectors. And I thought, my God, I read about this every day. In other words, some government official has done something that seems deceptive for a hidden political reason. You remember there's a case just a few months ago about a commerce secretary who said, we're going to spend millions to collect, a citizenship question on the census. And we're going to do it to, further the Voting Rights Act. Well, everybody, wait a minute, that's not true. His real reason is something else. Would anybody think that could be charged as a federal crime, a fraud crime? And about 2 weeks ago, I read that the vice president was going to meetings in Dublin, Ireland, on the east coast of Ireland, and he was spending the night, he and the Secret Service contingent, on the west coast of Ireland in a hotel owned by Donald Trump. Now, scrub the president out of this, and Governor Christie was not charged in this case. But suppose we learn that somebody in the White House staff, let's say Bridget Smith, called and said, why don't we have the Secret Service and everybody fly to Western Ireland and put up the people, and let's put out the cover story, we're doing it for security reasons, safety and security, even though they knew that's a false claim. So here's what, in asking the court to uphold this, here's the government statement. It says, the petitioner, her co-conspirators engaged in deception in order to carry out a scheme that deprived the Port Authority, think Secret Service, the Port Authority / Secret Service of its money or property, and served no legitimate Port Authority / Secret Service function. So I'm just raising the point that if this is a federal crime, that a government official used some money or properties and did it for a secret political reason, a deceptive political reason, is that a federal crime? Now, the briefs in this case are not, the merits briefs are not in yet. It was granted on the last day of the term in June, but I think it's a really potentially very interesting case on what is a fraud and what is a federal crime. And as I say, a lot of the discussion in the case is the concern is that it's very easy to look at the other side's people, other side's officials and say, they look like criminals, we should go after them. But anyway, I'll be interested to see. And we have, I was going to say 3 people who can talk about this case, but we have one member of the Third Circuit who probably should not weigh in on this because the case may come back. But do you guys have any thoughts on what do you think of this case? Because I thought it raised an interesting question about fraud prosecutions.
I'll say a quick word. I think in terms of looking at the court's trend or precedent, the most relevant touch point is the McDonnell case from a few years ago involving the governor of Virginia for engaging in various forms of graft, I think you might call it, where the court, I believe unanimously, in an opinion by Chief Justice Roberts, held that the federal fraud statutes could not be stretched to cover that, what the court itself described, I think, as unsavory political activity.
Yeah, he only took $175,000
right.
in gifts and things.
So that was a unanimous court, and here we go again. So I think if you're looking at the Vegas line on this case, you'd think that the court took this maybe out of a similar concern of overstretching the criminal law. And I think that's the other thing I would just mention and use this case as a platform to circle back to one of your earlier themes, which is the 3 cases that we talked about until this were constitutional or quasi-constitutional. But the the Supreme Court's criminal statutory decisions are perhaps among the most interesting decisions the court is issuing these days because it brings this confluence of the libertarian streak among some of the Republican appointees, some other together with some of the Democratic appointees, and you get into these debates about textualism and all this modes of statutory interpretation. So I think seeing how the court approaches this case in that respect will be very interesting as well.
Jeff, do you know, when is the last time the government won one of these cases? When I think of like broadly the fraud, is X fraud under federal law? It has been a while, I think, since the government has won any case. Like, if the question presented is X fraud under the federal fraud statute, the answer seems to always be no.
For the last decade or two, yeah. Maybe that's a better trivia question than the one I had earlier.
Well, Judge, how about if we talked in general about criminal law? I'm interested in your view about the court in general.
As I think I intimated, this is not your grandfather's court. In the Warren Court era, a lot of the issues coming before the court were, the way that you would Mirandize someone or how the exclusionary rule would operate. And those were ones that had some more predictable left-right divides. They were criticized by those on the right as technicalities. They were briefed in very pragmatic terms. The court has undergone a sea change on the kinds of cases it's taken, on the personnel, and on the ways it's approaching it. There's a lot of history in the briefs, even though policy and pragmatic arguments make it in there. I mean, several of these cases are heavily historical. The personnel are looking at these cases through methodological lenses that don't line up neatly with political lenses. So I think Jeff and I might both have at least added a cautionary note to the left-right divide that the panelists last night were sketching out. In criminal cases, you cannot pigeonhole some of these justices the way that you might on some others. And granted, it depends. You get to some death penalty cases, maybe the breakdown is a little different. And the other point I want to make is that a lot of these, both the substantive crimes and the procedural crimes, go to the fundamental things of what do we blame? What's blameworthy? What deserves punishment? And so, in the insanity case, we're certainly seeing that. Ramos, a lot of it's about who determines blame and how certain are we that someone deserves to be blamed. I mean, I think that's something certainly that runs through the juvenile cases too. What are the preconditions for making sure someone merits this sanction? And they're fundamental questions that lay dormant for a long time, and maybe, I don't know whether I date it to, Apprendi and Blakely, but it's really the last couple decades that these have moved to the fore of the court's criminal docket.
I agree with that. I thought that one of the really interesting cases to read at the end of the term was one that Jeff worked at, U.S. versus Gundy, on the, because I took some time at the, we're sort of rushing at the end of the term, and some of those cases, that case ended up deciding almost nothing, right? It was essentially decided nothing, but it was.
Decided that Mr. Gundy lost.
Yes.
That much was decided.
But I thought, I read Neil Gorsuch's, whatever you call it, the dissent, and Elena Kagan wrote this majority opinion, but they are arguing at one level about the non-delegation clause, but it's also a case fundamentally about, as Gorsuch said, there was something like 500,000 sex offenders who had committed crimes before 2008, and the question was whether this federal registration law applied to them, and whether it was applied retroactively. And Congress didn't decide that. It basically said the Attorney General should decide this. And Gorsuch wrote this long opinion basically saying, this is not the way to run the railroad. Congress is supposed to decide this. We shouldn't allow one executive to, it's somebody, I forget whether it was Gonzalez or somebody in the Bush administration basically decided this, and I think other administrations changed. And he had this very long opinion that I would have thought, if I scrubbed the names away, I thought, boy, this is a really liberal opinion. Here's a guy going out of his way to say we shouldn't treat sex offenders like this. This is not a fair procedure. And then Elena Kagan, taking the liberal view, had to say, oh, what's the big deal? We can trust the government to do. And I thought it was, if you looked at it as a criminal law case, it seemed like the conservatives were on the side of the criminal defendant, and the liberals were on the side of, oh, let's trust the government. It's close, as somebody said last night, close enough for government work. We'll just allow the government to, and most of the conservatives, people like me, write about them saying, oh, they believe in expansive government executive power. Gorsuch was arguing for the opposite, that we shouldn't allow the executive to make these kinds of decisions that are not reviewed. So for whatever it's worth, I think there are a lot of cases that you can actually read how they think about and decide, and they're not the typical view that the conservatives are against the criminal defendant and the liberals are arguing in favor of the.
Yeah, I mean, I'll just say a quick word. I think there's two ways to view Gundy. One is a criminal law case and one is not a criminal law
Correct.
Case, right? So I think the way the case broke and got decided was the not a criminal law case way, where it was one about the non-delegation doctrine more broadly and the concerns that Justice Kagan, I think, and her colleagues in the plurality had.
I thought
in
Kagan,
that
she
respect.
almost did this in one other case. I thought she had to do it a lot of times. Say something at the beginning of the opinion says, now this case is not about this case.
Yeah, right.
In other words, we're arguing something really big here, but it's actually not what this particular case is about.
But insofar as it was a criminal case, and Justice Gorsuch to some degree viewed it as a criminal case, I think it ties very much into a line of cases that the court's been developing. I don't think there's one on the docket quite yet, but the void for vagueness line of cases
Yes.
on the criminal side, and ties probably most closely this term so far into the fraud case we were deciding,
Yes.
where you have Justice Gorsuch and some other justices expressing, I think it's a relatively new and quite significant development of expressing great concern at hazy, flabby, broadly written, inchoate federal criminal statutes.
Right.
And right now, they've focused just on the federal side, but there could be state statutes that could be brought to the table as well, because void for vagueness is a due process rule. And so I think that's where the view of non-delegation and Gundy comes together with this concern about void for vagueness doctrine. And I think that, at least the void for vagueness angle of it seems to be, have a lot of juice in it right now.
I agree. We've got about 5 minutes left. If anybody has any questions, we'd be glad to take any questions. If anybody has any thoughts on criminal cases or criminal law, we would. Yes, Jeff?
Going back to your discussion of the public corruption cases, the New Jersey case, the Donald case, are you able why, or have any thoughts on why Rob Milovich's conviction was not reviewed by the Supreme Court, and what makes that one so solid, while the McDonald case and the Jersey case are up for scrutiny?
That was a straight up bribe.
I don't know it well enough to say, Jess. I paid attention to that for a while. Pardon me?
We were just discussing, and others may remember this better, but I seem to recall that was him just literally selling something, right? I mean, the person was paying him. And even in McDonald, I think the court made very clear, we're not saying that if, part of the problem in McDonald is there was no sort of, there was no allegation of a bribe directly to the governor. But even in McDonald, I think the court, when it's been narrowing these fraud statutes, it said, now of course, if you have like just literally bribery, someone just pays a government official to do X for them, we're not saying that can't be prosecuted. I think
That's certainly the way it was characterized, that he was selling his office, in effect, saying, you give me, now I do think there were campaign contributions, but if, you contribute to my campaign, or I'm not going to follow through on this particular hospital bill or something like that, it seemed like a much closer, Bridget Kelly and this guy, Baroni, I mean, as I say, they didn't get any money or property out of this scheme, and it was a political scheme. There seems to be even debate whether they knew, whether there was a traffic study or going on or not. But, so I think if you have a situation, I thought the Governor McDonald case was, I thought the court had to go out of its way to help him because, he took $175,000 in various gifts and loans. People said it was constituent service. I said this before, I think it is common. I lived in Virginia all these years. I had no idea that, that if I was promoting a product like a book, that the governor would hold a big luncheon at the mansion to help me promote my product. Because that's what he was doing with this guy who was trying to market these supplements using tobacco. Donald was getting all these gifts and use of his Ferrari and all that, and then using the governor's office to promote his product. And I said, what's the big deal? That he didn't take any official acts. He just set up meetings and tried to encourage other state officials to do something with this tobacco supplement. To me, that sounded more like an obvious case of corruption than something where it's like a mid-level person who's going to go to prison for, as I say, $3,000 paid unnecessarily for overtime for toll collectors. Seems to be a pretty small scale. Well, yes.
Mr. Deakins, you said something about how you have to be careful with the number of times or overruling cases through the Supreme Court. And my question was, do you have to be precisely careful about the number, and if so, why?
I think I was picking up off something that folks said on the panel last night in connection with the future direction of the Roberts Court. And there was a discussion that we're now in this relatively rare situation where you have the Chief Justice for the first time, I think someone said that since the 30s or 40s, that appears to be at the ideological center of the court. And we have a Chief Justice who is particularly an institutionalist and cares a lot about the institutional legitimacy of the court. And I think there is a perception that if you're a person who's particularly focused on that there is a cost every time you overrule a case in terms of the institutional legitimacy, public perception. And so I think I was sort of pivoting off that from the perspective, certainly from the perspective of people who are heavily invested in the court as an institutional player that has a reputation, or that you wish to have the court as a reputation, as the Chief Justice has said, is not a political body, that when the court sort of routinely overrules cases, particularly on predictable ideological lines, it strains this legitimacy and reputation in the way that at least many people care a lot about. I guess that's what I meant.
Well, thank you. We're about out of time. The next panel is at 10:10, so about 10 minutes from now. Thanks a lot.
Fun fact, I went to law school, Bill Barone. His nickname was the mayor.
Thank you, David. Well done.
I'm not making this up. I also, when I met him in law school for the first time, thought, I guess I never knew what a person who seems like a living embodiment of New Jersey is, and then I met Bill Barone. That person is easily a living embodiment of New Jersey.
It just
I prefer to think of Bruce Springsteen as the living
They're
embodiment.
different types, so.
jurors and judges and king were gonna make these kinds of assessments. Otherwise, we systematized and narrowed criminal law and refused to tell juries about punishment.
I see.
And really narrowed the questions before them. We just have this question about how much has to be before them in a way that in the past we just didn't.
Oh my gosh!
Didn't really have this issue. They
Now I
didn't
recognize.
consider that ever seemed relevant.
Oh my God, it's unbelievable. Yeah.
I'm going to go to the argument and pay attention, because I find it sort of hard to know how to draw the lines in this list, between the position on one side.
I'm not really sure how this one breaks down.
I mean,
That's what I've said. This is great. I felt like you gave us more than I thought. So I was talking about pretty standard stuff.
Yeah. So,
So you're just here temporarily and headed back?
No, it's Constitution Day in Montgomery. I'm usually here, and then I go to Philly and some stuff in
Constitution Center up there? Or?
I've already done them, but so I'm going up there, and then you guys know each other, right?
Yeah.
But I just want to say, like, I know it's crazy. Okay, so I just wanted to get into this conversation at some point about it's a sharp pressed guy. General one, not about this question. It's like, oh,
Okay, I'll catch up with you later.
Yeah, fair enough.
so I mean, you guys are running into different things, but aren't supposed to think about the slavery was split, like, I guess Mike McConnell doing the same thing, which is also, I think, part of Paul Day. So I think that'd be great. Yeah, this is awesome. This is good. Yeah. Okay, yeah, great to see you.
questions. The students in the overflow room can't hear when the audience asks stuff. You don't have to repeat it verbatim, just like generally summary. lost on some of the stuff. I mean, we're already lost as is, let alone.
They can hear everything here.
They can hear everything that goes through the microphones. Your way.
That's everything. Yeah, right. That's always a qualifying. All things considered. Right. Nice to see you. Yeah, David Officer.
Mr. Cole?
This is your chair.
I think we need to use last names here. Too many Davids up here.
Hey, nice to see you. Yeah. Do you know, is there a way to get onto the internet?
So
You have to do
you
is
have
it
to
really
use the
complicated?
wireless. Oh,
Well, you sort of.
Hernandez
against cross-border shooting case, which is really, I'll say this, it's really more a Bivens case than an immigration case.
I'm interested in.
We're going to get started in a minute. People can grab seats.
I'm interested in. If they say no Bivens, what it means beyond this.
Yeah.
Yep.
Yeah.
Thank you.
Yeah, man, what's you doing? God, go get cleaned up, man.
It's on right now. We still got 2 bars on the battery, so when we do lunch, I'll swap it out. Are we streaming lunch? Okay. And then with the microphone's on. Oh, okay. Oh, okay. All right.
Wait a minute. You have prepared remarks?
If everyone could grab a seat, we're going to get started.
I
always am prepared. I can do without the notes. I can do without the notes. I can do without the
I know you can. That's why I'm surprised.
I can do without the notes. I always have prepared notes. No, I don't need them.
I know, I'm kidding you.
Everybody, we're going to get started on, welcome back, welcome to immigration. Immigration is a rather quiet issue in this administration. Not much to discuss. Actually, one of the issues, 2 of the issues in the workbook, we're going to skip over with apologies to anyone involved in them so that we have more time today to discuss the DACA cases, to discuss the cross-border case, and then we're going to devote the last part of this to emerging cases. There are a lot of those on asylum, on the border wall funding, and other issues, some of which, 1 or 2 of which, could get to the court later this term, and we want to devote some time to that. So, as a matter of fact, just last week, just this past week, there was a Supreme Court decision on one of those asylum cases, and there are 2 others ahead of it. So we're going to try to devote about half the time to DACA, get to the cross-border case, and finish up with some of these other issues. I have the privilege of having Erwin and the 3 Davids here. So when I say David, all 3 of them can respond. I don't think we need too many introductions here, but Erwin Chemerinsky, Dean of Berkeley Law, David Cole, Legal Director of the ACLU, David Savage, one of my many mentors at the Supreme Court, has covered the court for 33 years and just moderated the last panel. David Strauss, I think on loan to Harvard right now, but University of Chicago Law. And we're going to jump right into DACA so that we, as I said, can get to some of the other issues later on. Erwin, you want to get us started on DACA?
Sure. Let me start by saying how wonderful is part of the preview. It's so special to be here. I think one of the most important Supreme Court matters this term, by any measure, concerns DACA. It's 3 cases that are consolidated for oral argument. One is Department of Homeland Security versus University of California. The second is Trump versus NAACP. The third is McLeenan versus Vidal. I think everybody's familiar with the underlying story. The Obama administration adopted a policy referred to as deferred action for childhood arrivals. It said for those who were brought to the United States under the age of 15, if they're in high school, or if they have a GED, or they've graduated high school, if they've been honorably discharged in the military, and they're under age 30, they'll be given deferred deportation status, something that exists under immigration law. The Obama administration adopted the policy. The Trump administration then announced it was going to rescind the policy. I said at the very outset this is one of the most important matters before the court, and it's true by any measure. It's true in terms of importance at the human level. This is going to affect about 800,000 individuals and whether they're allowed to remain in the United States. I think it's important as we think about the Roberts Court. To what extent is the Roberts Court going to rubber stamp Trump administration policies, especially in the immigration area, or is it going to stand up to the Trump administration in that area? This is certainly a case that could have important political ramifications. To tell a little bit of the facts of what happened here, really have to start with another Obama policy, and it was the DAPA policy, Deferred Action for Parents of Americans. And this was the Obama administration saying they would give deferred deportation status to those who were not citizens and not lawfully in the United States, but were parents of American citizens who were children. And again, it had to be individuals who didn't have felony convictions or serious misdemeanor convictions. A federal district court in Texas declared this unconstitutional and issued a nationwide preliminary injunction. The Fifth Circuit affirmed in a 2-1 decision, and it came to the Supreme Court in October term 2015. The court announced on the last day of that term that it was split 4-4, so it was affirming the Fifth Circuit by an evenly divided court. The state of Texas announced that it was going to bring a challenge to DACA based on the Fifth Circuit's decision and the Supreme Court's affirmation by an evenly divided court in the DAPA case. The Trump administration then announced it was going to rescind the DACA policy because of the determination that DAPA was illegal. And this becomes quite important. The justification that was given initially for rescission was the determination that DACA was likely illegal based on the DAPA decision. 3 different federal district courts ruled, one in California, one in D.C., one in the Eastern District of New York. The Ninth Circuit affirmed the district court decision in California. There were not decisions with regard to the D.C. case or the Eastern New York on appeal. The Ninth Circuit says this should be regarded as a reviewable administrative agency decision, and the Ninth Circuit says that the justification that's given by the Trump administration is that DACA is illegal. It's not illegal. It was a valid exercise of the president's prosecutorial discretion. The Trump administration, through the Department of Homeland Security, then says, we have other reasons for this as well. And they give several other reasons. They say, this is of questionable legality, and we don't want a policy that's of questionable legality. They said, we really think that this is a matter for Congress. They said there was no valid reliance interest. And beside that, we believe that DACA was illegal, that President Obama didn't have the authority for it. The Ninth Circuit issues a supplemental opinion saying those are all post hoc rationalizations. None of those should matter here. The original justification that was given wasn't valid, so this violates the Administrative Procedures Act. Also, I should point out that the Ninth Circuit had earlier said that the complaint validly stated a claim for a violation of equal protection. In fact, in the Ninth Circuit, one of the judges, Judge Owens, in a concurring opinion specifically said, there's a claim here that the rescission of DACA is a denial of equal protection. Similarly, the district court judge in D.C., John Bates, who had issued a preliminary injunction, said that the new justifications offered don't really change anything, and that therefore the preliminary injunction stands. The Supreme Court granted review in all 3 cases, the Ninth Circuit case, the 2 district court cases. At this stage, the Trump administration brief and 7 amicus briefs on its side have been filed. The respondents' briefs have not yet been filed. The Trump administration filed 1 brief in the Supreme Court in all 3 cases. I can tell you that there are going to be 3 separate briefs filed in the 3 cases by the parties, though there'll only be 1 argument on behalf of the parties because they're consolidated for that purpose. And the cases are going to be argued on Tuesday, November 12th. There are 2 issues that the Supreme Court granted cert on. The first is can there be judicial review of the decision by the Trump administration to wind down DACA? And it's interesting, they phrase it in their issues presented as winding down DACA. And the second issue that's presented was the winding down of DACA a violation of the law. As the former issue, the Trump administration says this isn't reviewable under the Administrative Procedures Act, that the argument is that this is arbitrary and capricious in the Administrative Procedures Act, but under Section 701A2 of the Administrative Procedures Act, this is committed to agency discretion, goes to a Supreme Court case, Cheney versus Heckler, that says that when there's matters that are committed to agency discretion, there can't be judicial review, and this should be regarded as committed to agency discretion. Now, as I said, we don't yet have respondents' briefs, but we do have the arguments that were made in the Court of Appeals. The Ninth Circuit rejected that argument, saying that the Trump administration is saying it's commanded by law to rescind DACA. That's a legal question. That's one that the court should be able to review, shouldn't be regarded as committed to agency discretion. In this case, could well turn on that first issue. Can there be judicial review at all, or is this a matter that's regarded as committed to agency discretion? Assuming the court believes that judicial review is possible under 701A2, then you get to the second question, is the winding down of DACA a violation of law? And the Trump administration says, we believe that DACA was illegal, but even if we don't say it's illegal, it was of questionable legality and we should be able to stay away from a violation of the law. They say this is really that should be something that left to Congress in the political process, and they say there's no denial of equal protection. I think it's easy to imagine what the other side's briefs will say. I think they're going to rely a lot as to this issue on the Supreme Court's decision in Department of Commerce versus New York from June 27th. In Department of Commerce versus New York, which was much discussed last night, Chief Justice Roberts said that the administrative agency has to have a legitimate reason for its decision. It can't be a mere pretext. There, Chief Justice Roberts said that the Department of Commerce didn't have a legitimate reason for asking a question about citizenship on the census. Well, here, the reason that was given by the Trump administration initially was that DACA was illegal, and the respondents said DACA wasn't illegal, that it was an exercise of valid prosecutorial discretion by President Obama. It's estimated there are about 11 million undocumented individuals in the United States. The government at most deports about 400,000 a year. And so what the Obama administration said is, we're just choosing among the few people to be deported that we can relative to the numbers who are here, not to focus on those who were brought to the United States under age 15. And the defenders of this are going to say, under immigration law, there is what's called deferred deportation status. And they can point to examples from many presidents, Democrats and Republicans, who've granted deportation status. And they're going to say that all of the other justifications given by the Trump administration later are just post hoc rationalizations, that this was lawful, and that therefore President Trump's justification as stated is invalid. And they also are going to raise their equal protection argument that this is really based on race discrimination against Hispanics. Finally, offering thoughts about what's the Supreme Court likely to do. On the one hand, you couldn't have more sympathetic plaintiffs than these. These are 800,000 individuals who were brought to the United States as children. Many, if not most of them, have lived their entire lives in the United States. Where are you going to deport them to? You're going to deport them to places where they never grew up, where they have no contacts. And I should disclose here that I was co-counsel in one of several suits that were filed in California on behalf of these individuals. And I do think there's a strong argument that the justification that was given by the Trump administration that DACA is illegal is just wrong. DACA was legal. On the other hand, there's several reasons to be skeptical that the Supreme Court's going to accept that argument. We've got to remember that the Texas versus United States case was a 4-4 split, which indicates that at least Roberts, Alito, and Thomas believe that DAPA and DACA are illegal. Also, I have to say that I think there's a tension in the argument that's being made by respondents. The core of respondents' argument is that the president has great discretion when it comes to things like immigration. Well, Trump's argument is, I have discretion, and I can then rescind this policy. That seems to me to create some tension. Also, if you look at the position of the conservative justices with regard to immigration in the Trump administration, they've sided with the Trump administration. Think of Trump versus Hawaii that was 5-4, or think of this summer, the order of the conservatives to lift a preliminary injunction against letting President Trump build the border wall, or what we're going to talk about from just this week, where a federal district court judge in San Francisco, John Tiger, had issued a preliminary injunction with regard to the asylum policy, and the Supreme Court stepped in, what appears to be 7-2, and stayed that order. It seems that the conservative justices and even sometimes the liberal justices are unwilling to stand up to the Trump administration here, which then would not bode well for the respondents. So that's at least the setup of the case.
That's an excellent setup, and I want to open this up to the panel, but one additional factor here, I think, is that, and it might be tempting for some of those in the middle of the court, if there is a middle on this case, perhaps it's Roberts, perhaps it's Kavanaugh, is that they could look to Congress to solve this. The president tweeted just last week, DACA will be going, this is his tweet, DACA will be going before the Supreme Court. It is a document that even President Obama didn't feel he had the legal right to sign. He signed it anyway, exclamation point. Rest assured that if the SC does what all say it must, based on the law, a bipartisan deal will be made to the benefit of all. So one question, and then we'll go to the panel, is whether anyone really thinks we're going to be deporting these folks, no matter who wins, or whether this is all a bargaining tactic on the part of the administration. So that and any other issues. Any of the Davids want to jump in?
A couple of thoughts. Just about the some of the positions that the administration took in this case. I guess three things. First, some of the things that my co-panelists said last night about the census case are even truer here. They said, you know, if the government had justified its position in a different way, it might have won the census case. I think that's probably true of the census case. I think that is clearly true here. I think if the administration had said, look, this is a discretionary decision, we're not saying that what President Obama did is unlawful. We're just saying it was his exercise of discretion. We choose to exercise our discretion in a different way. It'd be very difficult to explain why they can't do that. But instead, the very first justification was it was unlawful, it was unconstitutional, and then the subsequent things they said have the feel of post hoc rationalizations, whether they technically are in the administrative law sense or not. They have that feel a little bit. And now there's a sort of clear legal question. Well, was it unlawful for the Obama administration to do that? And that's a much more difficult question than can you exercise your discretion. So they've really put themselves in a difficult position. Second, it is really unusual for executive branch lawyers to disclaim power when there is any arguable basis for exercising that power. The reflex of most executive branch lawyers, certainly in the Solicitor General's office who are litigators, OLC is a little bit more judge-like, but certainly the executive branch in the SG's office who are litigators, the reflex is, you know, if we can make a plausible argument that the executive branch has the power to do this, we will make that argument. Now, we will say, look, we get to decide whether to exercise that power, but we want to make that decision. We don't want to hand it over to courts to make that decision on behalf of our administration and the executive branch as an institutional entity. And it's very odd, I think, for the government to take the position, as it did in this case, that no, we would not have had the power to issue DACA ourselves. That's really uncharacteristic. And I think, you know, that sort of thing is this kind of thing, depending on whether this sticks around, that can do long-term damage to the institutional interests of the executive branch. So that's I don't want to say it's surprising, because in some level it's not surprising, but in any other administration, a very surprising thing to see the government do. Third piece about this, also in terms of the interests of the executive branch, no one doubts that the executive branch, President Obama or any president, any executive branch, can exercise discretion about whom to deport. Irwin gave you the statistics. It is just inevitable. There'll be a lot of discretion exercised to allow deportable people to stay in the country, given the numbers 11 million versus 400,000. So there was no question about that. In the DAPA litigation, Texas said, oh, we're not challenging President Obama's decision not to deport these people. We're just challenging his decision to give them deferred action, this status that confers certain rights on you. But here's one of the things that's going on here Before DAPA, I don't think this was true of DACA, but it was true of DAPA. Before DAPA, there were directives from the Secretary of Homeland Security, or actually a subordinate official in the Homeland Security Department, to the immigration enforcement authorities what your priorities are to be in deporting people. And part of the problem was those weren't followed. That people in the field, because this is a massive and somewhat chaotic program of law enforcement, people in the field were not following those policies. They were picking people up and deporting them right away, even if they weren't, even if the executive branch's priorities dictated by the President and the Secretary of Homeland Security said these are not people who are high priorities for deportation. Part of the reason for conferring deferred action status on people is to make sure that won't happen to them, because now they actually have a card that says, you know, I have deferred action. You can't deport me. So part of what's going on with these programs is the executive branch asserting its ability to control what is going on in the executive branch, asserting its ability to control its own enforcement priorities. And that's why they give people deferred action status. When everybody agrees, they don't have to deport these people. And so it is really peculiar, from the point of view of the executive branch's institutional interests, really peculiar to see the executive branch saying, you know, we're not sure, in some cases we can't do these things that assert the power of the executive branch, and over something where you think it's really important that we keep control of this, because we need to set enforcement priorities, and we want to set them at the top, not have immigration officers in the field set them. So these are, I mean, I don't know if this will influence the decision of the Supreme Court, but they are really sort of odd, and even from the point of view of kind of the interests of the executive branch, really troubling developments in this case.
Well, just at the risk of playing the role of the skunk at the garden party, this seems to be I remember writing about after DACA, the notion was that this was a discretionary power of the president to say, and Obama said it in a very tentative way, that this was not even a formal rule, but as a matter of discretionary policy, we are not going to go after these young dreamers. They are the least culpable people. We're not going to seek to deport them. There was a lot of ruckus on the right about that, but I thought he had a reasonable argument to say this is within the discretionary power of the president to enforce the immigration law. And it sure seems to me that if the next president comes in and says, no, I don't want to do that, I don't want to maintain that policy, I think it was legally questionable, I'm going to not follow that. I'm going to, whatever it is, wind up. I agree with all the points about the humane aspect of it, the political, but I would think that if the president had the discretionary authority to make this immigration policy, the next president has the discretionary authority to repeal it.
Question is, I'm sorry, David, just one quick thing. The question is whether they can rule on that basis if it's not the question presented, and if the administration's argument is that it was illegal rather than he had the discretion and we
Why
had the
couldn't the court say that the administration thought this policy was illegal? They've now come up with several different rationales. I would assume the court would say they had multiple reasons of why they wanted to repeal it, and that's good enough.
So I think that David Savage's point is a reasonable point, but I think David Strauss's point that is not what the administration said. They didn't say President Obama properly exercised his broad discretion over this matter. We have similar broad discretion. We are going to properly exercise it in a different way. They took this position that I think was ideologically driven. If Obama did it, it must be illegal, and therefore we're going to, put that as reason A, with no other reason for why we are reversing it. And had they not done that, I think the challenges would have been much less effective. But having done that, they have made a discretionary power, turned a discretionary question, which may or may not be reviewable, but is not, even if it's reviewable, lots of authority to the executive, into a legal question. where the court is at its strongest. The only other thing I would say is on the political ramifications that Erwin mentioned. I mean, this is a extraordinarily cruel effort to take away from 800,000 people who did nothing wrong of their own volition. These are children who were brought to this country innocently, and to say, we're now going to send you home after you have developed your, you have become part of our community, not engaged in any wrongdoing. I mean, we have a number of DACA employees at the ACLU, people who went to Harvard undergraduate, who are devoting their life to public service, and to turn them around and throw them all out, it's just incredibly cruel. And I think in some ways, it's a real challenge for the administration and for the Republican Party, because on the one hand, there's a sense that we have to reverse it because Obama did it. That's the ideological part. And then there's the second, we have to placate and play to the Trump base, which is sort of reflexively anti-immigrant. But on the other hand, nobody really wants to see 800,000 innocent people who are productive members of the society torn from their homes and sent home. And so, in some sense, the litigation has allowed the Trump administration not to actually have to confront that issue, but at some point it may have to.
May I ask you, do you think that's actually what would happen? In other words, do you think if the government wins this case that they actually will begin to seek to deport these people?
I mean, well, we saw what Trump said in his tweet. No, there will be a bipartisan agreement to figure out a way to keep them here. But Trump has said, very contradictory things on this subject. Maybe this is the only subject on which he said contradictory things, but he's said very contradictory things. I'm not going to revoke it. Then he did revoke it. So I'm going to give it to Congress. So I don't think it's possible to predict what will eventually happen to these individuals, but the notion that you're going to put them at risk of deportation is...
Yeah, David, I think some will be deported. There's a case that I'm involved in Seattle, Washington, involving a man by the name of Garcia. The police were questioning his brother about something, and then they went to him and said, oh, what's your immigration status? And he said, I'm a DACA, here's all my registration. They said, we're not following DACA, and they began deportation proceedings against him. There will be those instances, and what David just said is right. The DACA beneficiaries will live in great fear that they're going to be next because they will no longer have the protected deferred deportation status.
Yeah, just to reinforce that, I mean, a big part of the puzzle, big part of the situation is how both chaotic and sudden these enforcement actions are. So, you get a tip that there are undocumented people living in a house, you go there, and yes, some of them are undocumented and not DACA people, but then there's someone there who is a DACA person. The authorities will round them all up if there's no DACA and just put them all into deportation proceedings. And these proceedings happen quickly, and if people don't have a lawyer, there's not much they can do. And that's a big part of this. It's not that they will set up to round up all 800,000 DACA people specifically. That's not the way it'll work. But if they happen to come across a former DACA person who's deportable, they'll deport him, and that's the real danger.
And keep in mind, they have the information of who has DACA status, should they want to go after them, because these were individuals who were registered. And Rich, this may go to your question, and it goes to yours, David, as well. I never thought we would see a time when administration would separate parents from children, as it did at the border, in such a cruel way. I didn't think we would see an administration set up concentration camps, and it's the only way to call what exists at the border now in the way that they have. And so when you think of the cruelty of those policies, could I imagine them going after those with deferred deportation status? Yeah.
We'll try to save time for questions on this before we finish. So let's move to the cross-border case, and David Strauss is going to take us through that.
Yeah, let me do this relatively quickly. This is, it is in some sense an immigration case, but it's probably more a Bivens case than an immigration case. So the case called Hernandez against Meza, it's making its second trip to the Supreme Court. It comes out of some terrible facts, which are a Border Patrol officer shot across the U.S.-Mexican border and killed a kid who was, according to the allegations in the complaint, playing a game where he would run across the border up to a fence that was on the U.S. side of the border, touch the fence, and then run back to the Mexican side through a culvert that the borderline actually ran down the middle of the culvert. And the allegation was that the Border Patrol officer shot him across the border. So he was a Mexican national, the child, and he was in Mexico when he was shot. Although the shot was fired by a U.S. Border Patrol officer from the U.S. side of the border. The parents of the child brought an action under Bivens seeking damages from the Border Patrol officer. Bivens, just to get everyone on the same page, Bivens is a 1971 decision of the Supreme Court that recognized, that allowed people to sue federal government employees for damages if the employee violates the plaintiff's constitutional rights. There is a statute, Section 1983, that allows a damages remedy against state and local employees who violate people's constitutional rights. There is no counterpart statute for federal employees who violate people's constitutional rights. Bivens established the equivalent remedy for violations of constitutional rights by federal employees. So they brought suit under Bivens. The Fifth Circuit said, well, we first have to figure out if there's a constitutional violation here. We think there's no Fourth Amendment violation because this is a Mexican national injured in Mexico. The other claim is there a Fifth Amendment violation because of a taking of his life without due process? The Fifth Circuit said, well, we don't know, but in any event, the official would be entitled to qualified immunity, which we don't need to get into for these purposes. Supreme Court then granted certiorari. This was in 2017 at the point where there's an eight-member court heard the case. Justice Gorsuch was not on the court when they heard it. And the court wrote a very narrow opinion saying, well, a Fourth Amendment issue, which the Fifth Circuit decided, that's very tricky, so we don't think that, we don't want to get into that if we can avoid it. They actually reversed on the qualified immunity question, but they said the antecedent question is whether a Bivens action is available here at all. And they remanded to the Fifth Circuit for the Fifth Circuit to decide whether Bivens action is available at all. Now, Bivens, as I said, was decided in '71. There were a couple of cases pretty soon after Bivens that also allowed Bivens remedies in different contexts. But since then, the court has very consistently refused to allow Bivens actions. Initially, it refused to allow it for fairly specific reasons, such as, well, there's an alternative remedy available. You don't need to seek damages from the official because you can get your relief from the government itself. But then over time, the court began to express increasing hostility to Bivens. And it eventually crescendoed in a case called Ziegler against Abbasi, if I'm pronouncing those correctly, an opinion by Justice Kennedy which basically just kind of kicked a lot of dirt on Bivens. And so Bivens belongs to an earlier era when the court was much more freewheeling in establishing remedies. We need to establish extending Bivens as a disfavored judicial action. It didn't overrule Bivens, but it sort of said we think Bivens should be confined. Well, actually said Bivens should be confined to the circumstances presented in that case. That case involved law enforcement officers, narcotics officers who kicked down the door of a house, arrested a person, handcuffed him, took him away without probable cause or a warrant. On remand, the Fifth Circuit said, well, the Supreme Court has told us to interpret Bivens very narrowly. There are lots of things about this case that make it look different from Bivens. Some of the reasons the Fifth Circuit said actually make some sense, such as this is a cross-border action. It involves action in another country. Congress has pretty consistently refused to allow foreign nationals to sue in these circumstances. Some of the things the Fifth Circuit said did not make a lot of sense, such as this will chill Border Patrol officials who have to make split-second decisions, but that's equally true in the context in which Bivens itself was decided. Anyway, qualified immunity is supposed to deal with those things. But the Fifth Circuit basically said, look, we get the message from the Supreme Court that Bivens is to be construed very narrowly. So we hold that a Bivens remedy was not available in this case. The Ninth Circuit, also dealing with a cross-border shooting that was egregious enough so that the government actually prosecuted the Border Patrol officer who did it, but the officer was acquitted. The Ninth Circuit held the opposite, held there was a Bivens remedy available. The court asked the Solicitor General for the government's views on both cases. The Solicitor General said, well, the Fifth Circuit had it right, there should be no Bivens remedy, but there's a conflict. Take the Fifth Circuit case, the Ninth Circuit case has some other complexities in it. Take the Fifth Circuit case, which is what the court did. I will be shocked if the court says anything other than Bivens is not available in this case. But as I said, this really is a case about Bivens and probably the latest chapter in the court's cutting back on Bivens. Itself kind of an interesting story, both interesting about what is going on and the way the court's thinking, and just interesting conceptually about should the courts have the power to create these implied remedies for which there's no statutory basis. Just to say one more word about that, Bivens involved an injunctive remedy. Justice Harlan, who wrote an important concurrence in Bivens, said, well, one reason to create a Bivens involved damages remedy. Justice Harlan said one reason to create a damages remedy is we've assumed for decades that the court can grant injunctive relief against federal officials who violate people's constitutional rights. Injunction, damages, both traditional remedies. In fact, historically, damages is a favored remedy. Why shouldn't we allow a damages remedy? The court has had no hesitation in allowing injunctive remedies. There's a recent opinion from Justice Scalia saying, oh yeah, injunctions, we can grant injunctions, long history of injunctions without statutory authorization, but damage is nothing doing. So there's a tension there, but I don't expect the court either to address that or to relent from its hostility to Bivens in this case.
So, David, I know you want to jump in. Let me just ask one thing. Yes, obviously, I think we know where Roberts, Alito, Thomas were on the first case. We have Gorsuch and Kavanaugh. Steve Vladeck, in his brief, mentions previous decisions by both of them. Is there any possibility for either one of those there? And David or anyone else, you can jump in.
I doubt it, but I mean, just because the impulse to say, look, this was from the era when the courts were much more aggressive in granting implied remedies, that impulse is so strong, but, conceivably.
I was just going to say, the Bivens remedy is not a friendly phrase for a newspaper audience. So if the court says no Bivens remedy, what does that mean?
Means you can't get damages from a federal official who violates your constitutional rights.
No suits involving cross-border, it'll be...
Oh, how broad it will be?
Yes.
This is mostly guesswork, but I would guess they'll keep it pretty narrow. Why not? The cross-border aspect of it really is, I think, a legitimate concern.
Without even using the phrase Bivens.
Well, if you say get money damages from a federal official who violates your constitutional rights, which is I think maybe comprehensible phrase.
Okay, sounds good.
Yeah. Go ahead, David, please.
Oh, I should just say we represent the individual in the Ninth Circuit case. I think in some sense the answer to how the court will rule was given by David's first comment, which is Bivens is a case decided in 1971, the end of the Warren Court era, and Bivens, speaking of stare decisis, has not been overturned, but they've come remarkably close, and they've done it in an incremental, step-by-step fashion until, what's left is you only have a Bivens action if your name is Bivens. And to me, it's not unlike the exclusionary rule, which they also have not overturned, but the court has incrementally cut back more and more to the point where it is the exception rather than the rule. I'm not optimistic. I do think that in some sense it is a classic Bivens case. Bivens was about a Fourth Amendment, a violation of the Fourth Amendment in a search, and this is the violation of the Fourth Amendment in a seizure. Shooting someone without provocation violates the Fourth Amendment. Yes, it involves somebody across the border rather than somebody a few inches on this side of the border, but that may be a merits question, but it ought not be a question about remedy.
Prior to Bivens, if someone wanted to sue a federal officer for a constitutional violation for money damages, it would have to be brought as a tort suit in state court. That remedy is available to the extent that state law allows the tort suits to be brought, and that would be the way in which money damages would have to be sought. Now, Justice Harlan, who David quotes, also said in Bivens, in his opinion, is for someone in the shoes of Wesley Bivens, it's money damages or nothing. In a situation like this, there is no injunctive relief to be had. And I think that Bivens was based on the premise, if there's a federal constitutional violation, there should be a federal remedy, and here a federal damages remedy. But I also agree, since literally 1980 in Carlson versus Green, there is no Supreme Court case that's held explicitly with Bivens that has ruled in favor of allowing the Bivens cause of action. The trend is what everybody on the panel has described.
We're going to switch. We got about 15 minutes, I think, maybe a little bit more. I'm going to go to David Savage to talk about the way in which some of these cases are coming to the court, the asylum case and the asylum cases and others vis-a-vis the SG's fast track strategy. And then we're going to go to David Cole, who has stepped into this panel and can talk about some of the specific cases. Among the 1,400 that he handles are some of the asylum cases and the leading border wall funding case. So, David?
Yeah, Adam talked about this a little bit on the panel last night. You know, the premise of this conference and a lot of other things in September, you talk about, here are the big cases that the Supreme Court's going to hear in the fall. They've been cases of they're going to review decisions of lower courts, hear arguments, and issue an opinion months from now. And were we sitting here and I were able to say, well, the Supreme Court this fall is going to decide a big case about border wall funding. It's really a great constitutional clash in a sense that the president wants $8 billion for a border wall. The House Democrats say no way. The Congress sort of shuts down. They end up with some agreement that funds the government, but no border wall funding. A day or two later, the president says, I'm going to invoke my executive emergency authority and appropriate money from other parts of the budget, the Pentagon's budget. The ACLU and others, the Sierra Club sues. A judge blocks it in Oakland. The Ninth Circuit blocks it. And in mid-July, the Solicitor General files an emergency appeal. On a Friday evening in late July, the court issues a essentially one-paragraph order with no reasons, really, for a 5-4 ruling that says, yes, we're going to lift those orders. The president can go ahead and spend the $2.5 billion. So a very, you know, and all the lawyers in the room would correctly say, well, that's not a final ruling. They didn't actually decide. But I would say for the most of the president's first current term in office through 2021, he's pretty much free to move the money around and spend the money even though Congress said don't spend the money on that. This is an interesting development. Now, on the asylum issue, you know, this has been the heart of the fight along the southern border. All these people from Central America and now apparently Africa coming, and President Trump has said the asylum law is sort of a mess, and I don't want to use that word entirely, but I think he's got a point that the asylum law is a little bit strange. It's got an open door premise. You know, it says any alien who is physically present in the United States or who arrives in the U.S., whether or not at a designated port of arrival, may apply for asylum. Early on, the administration tried to say, if you don't arrive at the port of arrival, you can't seek asylum. And the court late last year on a 5-4 vote allowed that to be blocked. 4 of the justices would have lifted that, even though the law seems to say it doesn't matter whether you're at a dead. But the second part of it is, once you get in to apply for asylum, it says you have to have a well-founded fear of persecution on account of race, religion, nationality, political opinion, or membership in a political social group. And my sense is that, I mean, I haven't looked at all these cases. These people are not fleeing political persecution. They're not members of a political or a particular social group. I can imagine, if they're gays and lesbians or something like that, they're being singled out because they're fleeing gang violence in their communities. Nonetheless, under the system we have, that they now have something like 400,000 pending immigration cases. So it doesn't seem like a great system. I was struck by the comment early on about the president said on DACA, if the court lifts this, we'll go back to Congress and work out some deal. It seems to me asylum is one of those areas where the administration should have gone to Congress in 2017 or 2018 and tried to make some modification in the asylum rules. But nonetheless, in mid-July of this year, they announced some new, quote, interim final rule that says if you arrive at the southern border and you have traversed, if you're fleeing from Central America and you didn't apply for asylum in the first safe country, which is Mexico, and you weren't turned down, you are ineligible. Federal judge blocked that. The Ninth Circuit blocked it, limited it to the Ninth Circuit. But, a couple days ago, the Supreme Court, another one-paragraph order, no reasoning, lifted those orders and allowed the administration policy. So that is a major change in asylum law, and as I say, a major change on the whole issue of border wall funding, both of them in, orders with no reasoning. It strikes me as not a good way to run the legal system. It seems to be, it'd be good to have Congress decide some of these issues, and it's not good to have them decided on this sort of fast-track run through the system where you make a big decision with all the justices are, around the country giving speeches or selling books or whatever, and in between they, issue this pretty big order. So that's my rant on that subject.
So David Cole, several of these are headed to the court. One is, you want to talk about the one that I can't pronounce, that is likely to be granted soon, and then the two East Bay cases, and on border the Sierra Club case. That's a lot.
That is a lot. Just to put the, let me do it in a slightly different order, just to put the asylum ban cases in context. I think what we have seen for the last several years is the Trump administration taking every action it can to deter people from applying for asylum. It began with family separation, what Erwin mentioned. That family separation was explicitly about maybe if we take babies from their parents, it will deter people from coming to this country and applying for asylum. That was literally the justification for separating families. The courts enjoined that. They then took they adopted a practice of de facto imprisoning you if you applied for asylum. So when you apply for asylum, you have a credible fear interview, and if you're found to have a credible fear, then you get to go before an immigration judge and you get your case heard, but because we don't have enough immigration judges, that often takes a year. And the Trump administration was simply locking people up and denying them any ability to be free while that determination was pending, whether or not they posed any risk of flight or whether or not they posed any danger to the community. We challenged that, enjoined by the courts. They then adopted a de jure. We're not going to give bond hearings to anyone who applies for asylum, so that it's not just de facto, but de jure. We challenged that. The courts enjoined it. They then adopted the policy, the first one that went to the Supreme Court, where they said, even though the statute says anyone who fears persecution at home can apply for asylum, whether they came to this country lawfully or not, the Trump administration took a position that if they came to this country unlawfully, they can't have asylum. Directly contrary to the statute, the courts enjoined it. That's the one that the Supreme Court denied the government's request for a stay. The most recent asylum ban is another crack at this, and that is to say, if you come through a third country and you haven't applied for and been denied asylum in that third country, we're not going to give you asylum. That is a clever way to effectively deny asylum to everybody from Central America other than Mexicans, because they have to come through Mexico, despite the fact that the statute specifies only 2 circumstances in which coming through a third country deprives you of the right to seek asylum, and that is where you have been firmly resettled in that third country, granted authority to stay in that third country, and then you come to the United States, but that's not what's going on here, or where we have an explicit safe third country agreement with a third country, and that's not applicable here either, so the Trump administration just overrode that as well. And then, of course, we have the border wall, where, again, the courts enjoined it because Congress said you can't have this money. Trump did everything he could to get them to say yes. They ultimately said no, and then he spent the money anyway. Again, the courts enjoined it, and the Supreme Court granted a stay. So it is a full frontal assault on asylees. There's still another one where they changed the standard for getting asylum. The Attorney General, Sessions, changed the standard, made it harder to get asylum. That, too, the courts have enjoined. That has not gone up to the Supreme Court. So there is a full frontal assault. And I think what this illustrates is that if the executive has tremendous power over immigration, and if it wants to make it really, really difficult for people to apply for asylum, it can do that. And it's extraordinarily difficult for the other branches to even keep up with what the administration is doing. The case that, and some of those cases may well go to the court this term, probably the most likely is the border wall case, because it's scheduled for argument in the Ninth Circuit on an expedited basis in early November, and so I expect we'll get a decision by, maybe by the end of the year, and that case may then go to the court depending on how the Ninth Circuit rules. The other case that I was asked to talk about is a case called DHS versus Thuraissigiam. I think that's the correct pronunciation of his name. He's a Sri Lankan individual who was subject to something called expedited removal, which is a statute that allows for the removal of certain foreign nationals, those who have recently entered and entered unlawfully. They are subject to a procedure that allows for a very summary administrative procedure, and then essentially no judicial review. The only judicial review that is available is if you claim, I'm not Mr. Thuraissigiam, and I can't even pronounce his name, so I can't be him. A mistaken identity claim is the only claim that is subject to judicial review. And so we have litigated this issue in 2 circuits, in the Third Circuit and in the Ninth Circuit, and they've gone opposite ways. The Third Circuit said, that's fine. The claim that we make is that under the habeas corpus provision of the Constitution, judicial review of people who are detained, and in order to deport somebody, you need to detain them, so habeas applies to the immigration, the action to deport somebody. There is a right to judicial review of a claim that you were unlawfully detained and therefore being unlawfully deported, and there are many ways, many reasons why you might be unlawfully detained and unlawfully deported other than mistaken identity. Like that the procedures that were applied to you were inadequate, or that the immigration judge incorrectly interpreted the immigration statute. Under the expedited removal statute, those claims are not reviewable. Our argument is that under the suspension clause of the Constitution, those claims must be reviewable unless Congress expressly suspends the writ of habeas corpus, which it has not done. The Third Circuit ruled against us. on that. The Ninth Circuit ruled in favor of us on that issue, and the United States has sought review on the basis of that circuit split. And it will apply to a lot of people, because the Trump administration has recently expanded the scope of expedited removal so that it recently applied only to people who were here who were caught within 100 miles of the border and had only been here for 2 weeks. The Trump administration recently expanded it, so it applies to people who are detained anywhere in the United States and who have been here less than 2 years. So it's a huge expansion of this process that provides for effectively no judicial review, and the question is that consistent with the suspension clause?
We're almost out of time. David, go ahead.
Well, I was going to say, suppose you win that, does it mean every person who crosses the border and they want to remove that person in an expedite has a right to a federal court review of his or her situation, or only a small group of people?
It means every person, and the predicate for that would be, that is where they have a statutory or constitutional challenge to their removal. And the predicate for that is the suspension clause applies, like all other provisions of the Constitution, at a minimum to all persons within the United States. And the court has, has said repeatedly that constitutional provisions apply to all persons within the United States, regardless of whether you're here lawfully or unlawfully. So yeah, and then the question is, what does the suspension clause require? That is a question which we litigated some years ago in a case called INS versus St. Cyr, where Congress also sought to restrict the scope of judicial review, and the court in St. Cyr interpreted the statute to preserve statutory and constitutional challenges to your deportation. So if it's purely a factual issue, no, but if it's a legal or constitutional issue, yeah, you have a right to judicial review. But that's been the case for a very long time. This expedited removal provision is relatively recent and has been, until the Trump administration recently expanded it, has been very limited in its application, so it hasn't applied to very many people.
David, one quick question for you, and that is what for David Cole, I'm sorry, and that is the different rulings that the Supreme Court issued on, I guess I'll call them East Bay 1 and East Bay 2. What's the rationale for going one way, and I guess we're talking about the Chief Justice going one way on illegal entry, going the other way on third country, and does it portend anything for merits if either of those get to merits at the Supreme Court?
Yeah. Well, they probably, the answer to the latter part of that question is yes, likely portend something on the merits, although, I agree with David, it's sort of unfortunate that that's how these cases are getting resolved these days. I can't read, only Joan Biskupic can read Chief Justice Roberts' mind, so I don't know how he drew that distinction, but I think what the government would argue is that the first case where the Trump administration said you can't apply for asylum if you didn't come into the country at a port of entry legally is directly contrary to the statute, because the statute says you can apply for asylum whether you came into the country legally or illegally. I am paraphrasing, but that's essentially what it said. In the second case about transiting through third countries, we're making an argument that's essentially a sort of implication. That is, Congress did not say expressly, you can apply for asylum even if you've transited through a third country. And then the Trump administration comes and says, no, you can't. That's what they did on the first one. On this one, they said, you can apply for asylum if you face a risk of persecution. And then in two other parts of the statute, they say you can't apply for asylum if you face a risk of persecution, if you've been firmly resettled, or if there's one of these formal bilateral safe third party country agreements with respect to the country through which you came. And so we say that implicitly that precludes the administration from putting forth yet another bar based on transiting through a third country, because Congress addressed the issue of transiting through a third country and said there are only two circumstances, neither of which apply to the Central Americans, that would bar. So I think that's probably the difference.
We're past time already. If anyone has a pressing question on DACA or anything else, I'll take maybe one question. Yes, there is a pressing question.
I was maybe less a question than a comment on DACA. Just to put the legal discussion in a broader context, I think there's a real political accountability question in this case. The president wants to be able to say, it's not my fault I'm terminating DACA. It's just illegal. I wish I could do something to the Dreamers, but I can't. And that's both political accountability, and it's also a way to force Congress to act, right? By saying it's illegal. The only way you can protect the Dreamers is if you make a deal with them, even though you rejected a whole bunch of deals previously. And then in response to David Savage's comment about deportation, deportation is part of it. Work authorization is much more important. These people, as a result of having deferred action because of longstanding policies of the executive branch, they have work authorization. They get to actually participate in society. If DACA is eliminated, even if you're not deported, you're going to lose your job. You're going to use your ability to go to a hospital because you might be deported, and your life is sort of destroyed.
Good point.
I know we have people in overflow. Let me just tell you that that was Andy Pincus, and it wasn't a question; it was a comment. So I'm not gonna even try to repeat that. Anyone else? Quick. Yes, Allie.
I was curious about your thoughts on the first question presented in the DACA case about availability of judicial review. It seems like an attractive off-ramp for the Chief Justice, but can it be squared with the census case? What do you think will happen?
It's a great question. What the Trump administration is saying is that under 701A2, if it's about arbitrary, capricious review, it's committed to agency discretion and there shouldn't be judicial review. But what the Ninth Circuit there said is when it's a question of law, and the Trump administration is relying on a question of law, it's ultimately for the courts to decide question of law. In fact, Judge Wardlaw's opinion in the Ninth Circuit quotes the language of Marbury versus Madison, that it's the province and duty of the Judicial Department to say what the law is. And there is such a parallel to the census case, because in the census case, what four conservative just said is, we just shouldn't be reviewing this at all. And yet the majority said, yes, we've got to make sure that there is a legitimate justification and that there's been a rational stated ground given. And that's exactly what the respondents are arguing here, that the justification given isn't a legitimate one, and they've got to go back and come up with a legitimate justification.
Can I just add one thing to that? We know that at least 4 of them thought that DAPA was reviewable because they would have struck it down. And we can guess which 4 they were. The government in its brief actually has a line trying to explain why DAPA was reviewable and DACA is not, but it's pretty thin distinction. So I wonder if 4 of them, if they'll be stuck. I mean, I'm sure that, those are 4 conservatives. And I wonder if they'll feel, look, we've already said this is internally, we haven't written it, but we said internally it's reviewable, and we'll feel stuck.
We are eating into the time for Just Braven's business panel. Jess, do you have a question? We're going to call it we're going to put a 30 at the end of this. We'll probably take, 5 minutes and come right, 10 minutes, Neil says, and come right back. I want to thank the 3 Davids and Irwin for the panel.
It's a pleasure.
Likewise. Always good to be next to you.
Likewise.
And we're doing it again, right? On the surprise
panel together, so we get to do that.
Thank you, guys.
You got a hard case there.
No, Bob asked me, I'm not going to present my case.
Bob said you have to present it as a springboard.
Yes, that's exactly right. That's exactly right. Now, I don't know how Paul's going to present it. I think we know some strong arguments if they really want to follow what they've said before.
Yeah.
That the cases that have found but-for causation really address because of language. It's like Gross and Answer. 1981 doesn't prove that. What the other side's briefs don't recognize, I sent Paul a copy of our brief. In Peterson versus McLean in 1989, the court explicitly says we're going to use the burden-shifting approach, not but-for causation, for Section 1981. Congress amended the Civil Rights so I think there's a strong argument that says, on the other hand, I'm not naive.
Yeah, yeah,
It's a civil rights case that's
yeah.
going before the Roberts Court. But I think we have good arguments. I was sad to see, and I made my pitch to the SG's office that they should turn on our side. They didn't. It's a civil rights case, and they're not going to. I know. It's the day after the DACA case in Hernandez versus Mesa, November 12th, and the Comcast case is the next day, November 13th.
Good luck. It's kind of amazing that you're doing that on top of everything else. Hopefully you have some good help at Berkeley.
I have terrific research assistants.
I mean my associate.
I have great assistants. I brought my CAO with me. He's a terrific
That's
and we have a new CFO who's great. And then I inherited some terrific assistants and I replaced some who weren't terrific, but I replaced them with great people.
So it's all going well?
We just hired 9 people. Even for a big school, 9 people.
And you have Judge Bill coming over.
Yes, we do.
I'm jealous.
Well, come out.
Yeah, I should find somebody. I should find somebody.
Oh, you're invited. Tell me you want to come. And ironically, we arranged for her and another judge. Every year there's 2 judges in residency. The other is Andre Morano, who's the scientist. And then Elena Kagan said, what date? You should pick the day because they're there. So Elena Kagan will be there Monday, we'll be there Monday and Tuesday. And it isn't how I would plan it.
Right. You want to spread them out.
Right, but on the other hand, it's,
Exciting.
so we'll do a small dinner at our house Monday night. It'll be great for the students.
Well, let me look at my schedule, because I would love to come out at some point.
You let me know what works.
All right.
You know, in winter, in New York, D.C. is a good time to come.
Yeah, absolutely.
You just pick the day, and we'll arrange you to come to a talk on anything.
All right, thank you. How are you?
just, you know, I'm representing the House on the border walk.
So I have a few
It's
notes.
the most frustrating case in the world.
And I will come down.
Especially if it doesn't work this time, I don't want to be blamed. So.
I just want to do it.
Well, I'm glad you're in there.
I want to keep students happy.
Yeah, I wish we had a better argument for standing.
Stop at 12:50.
Yeah. Not ever does.
Well, good luck.
Yeah, so we're in Arkansas. It's in the 8th Circuit. Worst places to be. Worst places to be. But, which case are you talking about, Ken?
I am talking very toughest Georgia copyright case, this case on annotations of state statutes. So amazingly, two of my partners wrote this very handy 2-page summary of the case. So,
Wow, we can just give
I'm
us
just
some
going to
dramatic
basically
reading.
read this.
Yeah.
It's very well done. But that's right. This is what the board, I think, will do is we're going to start with you, Paul.
Yeah, right. The other Cooper.
Yeah.
Yeah, right. Right.
And then we're going to take I think to your case, you get the human weight, you get all the exciting case. And then we wrap up with
Picking off Puerto Rico.
Puerto Rico, in case everybody.
When I think about business cases, I think about Puerto Rico. Think about Puerto Rico and the appointments clause. What else? Maybe combined.
I think you can say sometimes the business cases are about regulation. These 4 cases are all about money. Pure and simple, who gets the cash?
I wonder how much money Lexus genuinely gets from its annotated Georgia code, but it's probably more than any of us would guess.
There's a lot of money in the risk orders.
Well, they get some money from the online.
There's a lot of money in the risk orders.
Right. No, I would. Yeah. I assume that they have that annotated version only on Lexus. I had not known. Opposite friend of all that Lexus is really keeping afloat right now is they're requiring law firms if they subscribe to Law 360 also to subscribe to Lexus for all their returns because Law 360 is now all Lexus property. I didn't realize that, but it is interesting given that I think most associates, given their brothers, would probably prefer to use Westlaw.
I have a friend who works for Thomson Reuters, and a few years ago I went to see them and I said, the product you should be worried about is Law 360.
Oh, I think they're totally worried. Apparently they're feverishly hiring reporters to try to turn their Reuters.
Well, it's crazy because they should be able to do it. I mean, they have the raw material, but they haven't put it together. It's very weird.
No, I think they're really worried about the effect this is going to have on us.
So, like, does anybody read Law 360? I hope not.
Yeah, but it's lawyers.
I might have to start like returning calls.
I think they're read in the same way that like TMZ is read, right? I think it's just everyone gets it. Yeah, it's kind of interesting. Reporting is not always very precise.
Well, it's like it's interesting. It's interesting when they tell you like, you know, who made what based on their disclosure. But it's not interesting. Like they do those, right? Like those little articles. Or no, where's that?
Law 360 do that stuff.
I think it's the morning emails that tell you, you know, what cases came down the day.
Okay. I just don't.
But it's funny when you read those. When you read their description of the cases, they always say we reached out to lawyers on both sides, and nobody would talk to us.
Yeah, I don't think to me it's the case because they reach out to you at 6 o'clock and say our deadline is 6:30.
And I say I don't have any time to deal with you. I have no time to deal with you.
That's your question, which doesn't really matter anymore.
There's natural tendency to assume that what you do is wrong. And so since I don't read that,
I think what I do is closer to what you do than what apparently the rest of the world does. But you know, it's interesting.
Yeah, no, that's fascinating because I would not have, based on my.
I think they're making money already that way.
Yeah. Making money. That sounds good.
Not many, but most of it. So.
So,
great panel. I wish the cases were worthy of our panel.
All right, hello. Okay.
I'm happy to sit.
All right. Ooh. And now the moment you've all been waiting for. The business panel. I'm Jess Braven. I cover the Supreme Court for the Wall Street Journal. As I think we all feel, thank you to Professor Neil Devens and the William and Mary students and faculty and crew here for this event. It's I think it is to us in the Supreme Court world, like Labor Day for students. It's the end of fun and the return to work. We're very fortunate to have a great panel here on business law. A panel, if only the cases were worthy of the expertise that we have here, for litigators who really have had a huge influence on business law and other forms of law as well over the past decades. They don't need much introduction, but all of them have worked for the Solicitor General's office, and Paul Clement was in fact Solicitor General under President George W. Bush. He's now at Kirkland and Ellis. We have Carter Phillips, who's next in line at Sidley, Canon Shanmugam at Paul Weiss, and Andy Pincus at Mayor Brown. He also was relevant to the business law discussion, General Counsel of the Commerce Department previously. So their expertise is great, and let's now squander it on the cases we have this year. We have two intellectual property cases involving state governments, and when I first saw Allen versus Cooper, I was hoping I'd be able to moderate our panel on piracy and law, but it turns out to be copyright piracy, but piracy involving one of the legendary privateers of the 18th century. I'm sure all of us know that 25 years after this school was founded, the ship that Blackbeard renamed Queen Anne's Revenge grounded off Beaufort, North Carolina, leading to about 300 years of litigation. And we're going to ask Paul Clement to tell us about that case and why it matters.
Well, thank you, Jess. It's great to be here. Really, the only reason to talk about this case was to be able to make a joke about pirates and copyright pirates and Blackbeard. So Jess has already done that. So I'm going to keep this. I'm going to keep this short. This case is really, in the end, I think a little less a copyright case than kind of a return to the 11th Amendment for the Supreme Court. As many of you may have known, like the Supreme Court about a decade and a half ago sort of went through pretty systematically and looked at a variety of federal statutes that provided expressly for a private damages remedies on behalf of private individuals against essentially any defendant, including expressly state governments. And the court pretty methodically and pretty much by a 5-4 majority, but one interesting exception towards the end, went through those statutes and said, no, you can't do that, Congress. There's an 11th Amendment problem. No matter how clearly you try to abrogate the state's sovereign immunities by making it crystal clear that you can bring a private individual can bring a damages action against a state in federal court. You don't get to do that, at least under Article I of the Constitution. And then they came up with a doctrine how you can sometimes do that under Section 5 of the 14th Amendment, the proportional incongruence doctrine. And there are a whole bunch of these cases where most of the time the 5 more conservative justices would vote to say that there was an insuperable 11th Amendment problem, and in most of the cases, the 4 more liberal justices would dissent and basically say, we think you're making all this up, the 11th Amendment doesn't even say this textually, and we're going to keep dissenting because we don't like this line of cases. And then, the court
largely took 10 years off. But one of the last cases in the line was a case called Katz that I think to everybody's great surprise, or at least to my great surprise, the court, because Justice O'Connor, with like her last judicial act, kind of switched her vote and voted with the traditional dissenters and said that the bankruptcy code could apply to states, and notwithstanding the fact that the court had said pretty emphatically in a case involving patents that you can't abrogate state sovereign immunity under Article 1, the bankruptcy power, which is located in Article 1 of the Constitution, somehow got it done. I always thought that case, just as a footnote that's maybe more interesting than most of the rest about this case, I always thought that case was actually like a great case that showed the Supreme Court as a pretty awesome institution, because the Katz case came down literally on like Justice O'Connor's last day on the court, and the 4 dissenting justices, if they wanted to, I mean, they knew Justice Alito was coming down the pike. They probably had a pretty good sense that he had a different view of the 11th Amendment than Justice O'Connor was manifesting in that particular case. And, you know, they could have just sort of said, you know, our dissent's just not quite ready. We'd just like to fix a few more words, so we got to kick this over a week or two. And they didn't. And so the court issued this Katz decision 5-4, and it's really the only case that says that there's a continuing, only modern case anyways, that says that the court can abrogate 11th Amendment immunity under Article 1. So this case it does involve Blackbeard and photos of the wreck of the ship, which is pretty interesting, but none of that really matters for the issue before the court, which is just whether you can essentially, as a private party, sue a state in federal court for copyright infringement and get damages. Congress, plain as day, said absolutely, states can violate copyrights no less than anyone else, so you should be able to sue them no less than anyone else. That's generally actually kind of a bad formula, though, for winning an 11th Amendment case in the Supreme Court, because, you know, states are different from everybody else. So, you know, having clear congressional history that says that they wanted states to be treated like everyone else isn't necessarily such a great thing. But it's interesting anyways that the court took this case, because the lower courts had pretty uniformly said that, yeah, we're just going to apply the old patent case and some other cases and say that there's really nothing to see here. This is unconstitutional. This is the rare constitutional case where the SG presumably won't appear. They haven't appeared yet, and they've previously filed a letter with Congress saying, we think this is hopeless, so we're not going to defend it. I mean, it's phrased a little different, but that's the gist of it. And that's not a partisan thing either, because the first of those letters was sent at the end of the Clinton administration, and the most recent one was sent under Jeff Wall's signature. So kind of consistently, the SG has looked at this and said, no, we think the prior cases are controlling. So I think, you know, the safe money is probably on, well, certainly the safe money is on a 5-4 decision, I think. And the safe money is probably on the court saying, you know, the bankruptcy code is really, really different. And the copyright law is more like most things in the Article 1. And so, you know, this probably doesn't get it done. That's my sense of where the safe money would be. I'd say 2 interesting things. One is, given how, you know, fairly foreclosed this seems to me to be by the court's decision about patent remedies, I think it's pretty interesting, like, how much amicus support the petitioners have been able to get in this case, and, you know, that's a tribute to Petitioners' Counsel for generating that. They've also gotten some support in some somewhat unlikely places. I mean, you know, I wouldn't have necessarily thought a priori that the Chamber of Commerce and the Washington Legal Foundation would be kind of up for limiting 11th Amendment immunity of states, but they're on the plaintiff's, the petitioner's side on the case. And then there are lots of other people who just, you know, really, really like copyright laws and really, really think it's bad for the states to get to infringe them and get away with them. And that's a perfectly understandable impulse. That's clearly the impulse that manifested itself in Congress passing the statute. I don't know that that's going to move the needle too much from the 11th Amendment perspective. The one last thing about this I think may be interesting is I think the court could kind of in passing say something interesting about kind of the nature of copyrights. There's sort of a debate going on right now about copyrights and patents and how much are they like real property. I mean, how much are they like kind of true property that like conservatives should be really excited about defending against sort of infringement and taking, and how much are they just kind of like any other sort of regulatory, think about them as like, say, a state-conferred monopoly, which you'd think conservatives wouldn't think is so great. And there's a big debate going on about that in both the patent and copyright space. And the court could say something about this because one of the arguments as to why it's okay for Congress to abrogate immunity here is putting aside the Article 1 power, you can think about all of these various private damages actions preventing a taking from happening, because otherwise the state would be taking private property. And so that argument, I don't know how the court will react to it, but in order to accept that argument, the court would have to, I think, at least indicate that copyrights are some kind of like real property, not in the sense of land, but in the sense that they are true property interests. And if the court rejects that, I think it's probably going to suggest that no, copyrights and patents are a little bit more like regulatory provisions than not that special.
Can we talk about pirates a bit more? Because the facts of this case, just to briefly say what they are, since I have a feeling that my colleagues in the press may emphasize that angle more than the theoretical construct of copyrights. And that is that this ship, which ran aground, it was salvaged, and the state of North Carolina essentially made a deal with a private salvage company to bring it up, and since the state, I suppose, owned it or through its territorial waters, and the salvage company financed its operation by selling a documentary rights, in other words, to make a film about salvaging the ship, and the state, which owns the ship, got rights through this agreement to post some photographs and to distribute educational materials related to the ship. And so the question here is really between the documentary maker says the state went too far and put too much material online for free, interfering with his copyright in the material, and the state says no. I would say that even if there is a right of action, the facts in this case are they're not open and shut, and the state even has a quite strong case just on the facts, even if it could be sued because they did post this material on their state website related to culture and education and so forth in North Carolina. Are there any other cases that we have that are similar to this that are floating around? I mean, where states are being sued? I mean, I suppose this is a state law school. They could publish a syllabus including all kinds of copyrighted works and be free of liability if the state of North Carolina wins?
Well, there definitely are implications for, and one of the things that the petitioners do very effectively is they point out that when Congress passed the statute extending the liability to the state governments, that they actually documented a lot of instances in which states behaved badly vis-a-vis copyrights, and a lot of that is in the university space. So that's one potential place where there could be liability if this case is decided that way. So the issue is really not whether states can violate the copyright laws, because of course they can, and it's not even whether Congress thought that they should pay for it because they were explicit. It's really just about whether they can do that consistent with the 11th Amendment. The one last thing I'd say just about pirates. Personally, Blackbeard is only my second favorite pirate, with my first favorite pirate being the dread pirate Roberts from The Princess Bride. And since that pirate's name is Roberts, somebody in the press corps ought to be able to do something with that. I hope. Anyway.
Thanks for the tip, as always. We have, amazingly, another state intellectual property case coming up from Georgia, and that has to do with the Georgia State Code annotated. And I'd like to invite Cannon to tell us about that bit of piracy.
Great, thank you, Jess. I had an even more elegant transition, which was that I actually once represented the alleged Dread Pirate Roberts, Ross Ulbricht, before the Supreme Court. But that's an issue for another day. I am going to talk about the other copyright case on the court's docket. It is usually the job of headline writers to make articles sound more interesting than they in fact are. And I pulled an article that two of my partners had written about this case, and the headline in the National Law Journal was SCOTUS to decide copyrightability of Georgia Code annotations, which I suspect did not provoke the good readers of the New York Law Journal to read further. But it turns out that this is actually a modestly interesting case, particularly if you're an employee of LexisNexis or West. Let me sort of lay out the facts of this case, and it's a pretty simple case, I think, to understand. The state of Georgia, like many states, has entered into an exclusive contractual relationship with an outside party to produce the official version of the state code, the Georgia Code. And in this case, Georgia entered into such a contract with LexisNexis. And as part of that contract, LexisNexis has the obligation under the contract to produce annotations for the statute. And at least the law students in the audience will know that those annotations contain commentary. They often include citations to other materials, law review articles, official opinions of the Attorney General, and the like. And the question in this case, at bottom, is a very simple one. It is whether those annotations are entitled to copyright protection under the federal copyright laws. Now, you might wonder why this is a question at all, and the reason why it's a question is because of a doctrine known as the government edicts doctrine. And if you haven't heard of that doctrine, you're not alone, because I have to admit I had never heard of it until I started reviewing the briefs in this case. The government edicts doctrine is a doctrine that was adopted by the Supreme Court in a series of cases culminating in 1888, which may explain why some of us have never heard of this doctrine. But it originated actually in a fascinating case called Wheaton versus Peters in 1834, and it was reported in 33 U.S. 8 Peters. And so the Peters of Wheaton versus Peters was actually, like the Wheaton, a Supreme Court reporter. And many of you will know that back in the day, as now, there is a reporter of decisions, but back then the reporter of decisions literally reported the decisions of the Supreme Court, and there was a question about whether the reporter could get copyright protection for these opinions that the reporter produced. And the Supreme Court in Wheaton versus Peters said no, on the theory that, in the words of the court, no reporter has or can have any copyright in the written opinions delivered by this court, and the judges thereof cannot confer on any reporter any such right. Now, in the wake of that decision, there was a precipitous decline in the number of applicants for the position of reporter of decisions. It became much less lucrative after the reporter was no longer able to get copyright protection, but the Supreme Court eventually extended this doctrine not only to its own opinions, but also to statutes passed by Congress. Now, fast forward to 2019, we now have a much more reticulated Copyright Act in Title 17 of the United States Code. And in, I believe, Section 105, there is an exception to copyrightability for the works of the United States government. There is no corresponding exception for works of state governments, but I think everybody agrees that at least the text of state statutes would fall within this Supreme Court created exception to copyrightability. The dispute in this case is whether the annotations are sufficiently analogous to the text of the statutes themselves to also fall within the scope of this doctrine. And one of the earlier Supreme Court cases did suggest that where you have annotations to court decisions that are actually produced by the court officials themselves, that they would fall within the scope of this government edict's exception. So there is some genuine ambiguity in the law. In the decision under review, the 11th Circuit said that the annotations were not entitled to copyright protection, and the 11th Circuit relied on the fact that these annotations were produced under the supervision of the Georgia Code Revision Commission, believe it or not, there is such a thing, which consists of the lieutenant governor and various members of the Georgia legislature.
That's what the lieutenant governor does. Okay.
The lieutenant governor supervises the annotations to the Georgia statutes. It's an even better job than being vice president. So Georgia and the commission go up to the Supreme Court. They say that there is a circuit conflict on this issue, and they seek the court's review. The respondent in the case, and I should sort of step back and provide a little bit of procedural background as to how the case actually started. What happened is that there is this group called public.resource.org, which is devoted to essentially making public various government resources. And they decided to just post on their website the official annotated version of the Georgia Code. Not surprisingly, they were sued for copyright infringement. And so it is in that context that this issue is being litigated. Georgia and the other plaintiffs in the copyright infringement case go to the Supreme Court and they say the 11th Circuit's decision is wrong and there is a circuit conflict. Public.resource.org files one of the more unusual quote-unquote briefs in opposition that I have ever seen. In this brief, they say there is no circuit conflict here. The 11th Circuit got it right, and you should nevertheless take the case. Which is not typically the way that briefs in opposition look before the Supreme Court. And, all I can say is that, number one, perhaps this group wants to run the risk of snatching defeat from the jaws of victory, but they were last seen winning in the 11th Circuit in the copyright infringement case, and so it strikes me as sort of an odd judgment to do that. I do think that oftentimes lawyers who represent respondents also have something of a conflict of interest where there is sort of a personal desire to get a case to the Supreme Court, but one would ordinarily think that it's in the client's interest to try to keep a case out of the Supreme Court. But this is a very unusual document, and perhaps not surprisingly, in light of the fact that the respondent really didn't dispute that the case should be in the Supreme Court granted review. Now that the case is in the Supreme Court, I do think that petitioners have a pretty high likelihood of success on the merits here. You often see these cases come to the Supreme Court where you have sort of a hoary old judicially created exception, and then you have plain statutory text. Here, I think that the statutory text, while everyone recognizes that there must be some form of an exception, I'm not sure that the court is going to have any particular incentive to read it broadly. And there is sort of a real sense that these annotations, were prepared by LexisNexis. The degree of supervision by the lieutenant governor and the other members of the commission was not very close. And you also have the Copyright Office supporting the petitioners here and arguing that there should be copyrightability. So I think it's somewhere between likely and overwhelmingly likely that the petitioners are in fact going to prevail and that respondent is indeed going to snatch defeat from the jaws of victory.
Did they copyright that brief of opposition? I was wondering, are there other states that have a similar setup, or is this unusual?
It is not an uncommon setup, and to be fair, that was one of the points that the respondent made, is that there are a number of other states that have similar setups. My interest in this case did not extend to digging into the statutes of all those states to see just how similar they are, but just from anecdotal experience, if you've ever looked online, it does seem as if LexisNexis and West, and I think Michie's back in the day, in many, many states, they have these sorts of arrangements simply because back in the day when there were actually books, I think a lot of states needed to have these contractual arrangements in order to ensure that their state codes would actually be published and widely disseminated.
Certainly in criminal cases, the Supreme Court has made a big point about there being fair notice to the public about what the law requires of them, and that's I wonder, does that principle that the court has spoken of run into conflict here, given the nature of this particular copyrighted material?
I think that is certainly one of respondents' arguments, the argument that, in some sense, this sort of, bundling, or rather that's sort of, I think, one of the arguments that really sort of both sides make. I mean, petitioner's argument is the argument that, you need to have this sort of incentive in order to ensure that there is publication. respondents' argument on the other side is that, this is a very close adjunct to the statute. Some of the material that's contained is kind of quasi-official material, the opinions of attorneys general of the state of Georgia, and there's a sense in which, that if you feel that that is adjacent enough to the statutory text itself, perhaps respondent can get some mileage out of the fact that everybody agrees that the statutory text is analogous to, say, a judicial opinion and needs to be in the public domain. That was, after all, the genesis for the government edicts doctrine. I just think that the court is ultimately going to likely reject that premise and say that the annotations, feel like traditional creative material.
Even though the state has
I filed a brief in this case. It's interesting because there actually are Georgia state court decisions holding that the annotations have no legal force, which is a sort of a problem for the respondent. But this case is a little bit of a stalking horse for a bigger issue, which is a lot of building codes and other laws incorporate privately designed and adopted codes of construction, fire safety, et cetera.
National Electrical Code.
And a lot of the ways those people support the effort to produce those codes is by selling them. And so there's a much bigger fight out there in the courts about whether those private codes that are incorporated into law can be copyrighted given their status as incorporation. And it wouldn't be shocking if one of the reasons the respondent wanted to get this case up there was to get the court, even if they lose, to try to say, well, yeah, these things don't have the force of law, so they are copyrightable, but these other kinds of things are on the other side of the line.
It also seems somewhat oddly as if, to the extent that there was other lower court authority on this issue, a lot of those cases did involve sort of like tax maps and other, factual permutations. So there is, potential broader significance of this beyond code annotation. So I kind of find it hard to imagine that there's going to be an opinion that isn't a fairly context-specific opinion here. I think the court will presumably be aware of, from the amicus briefs, these other implications and want to write narrowly.
Right, because we have seen a movement to put more material online and make it more accessible to the public, these sort of, documents and rules and, official records or quasi-official records. So it would be interesting if that, if they ran into a copyright issue restricting it. Let's now turn to something that involves an element really at the heart of most business cases, money. And we have before the court yet another Obamacare-related case, Moda Health Plan. And Andy, can you walk us through this and then help us file our insurance claims?
Yes. So for people who worry about the health of the Affordable Care Act, a grant by the Supreme Court of an Affordable Care Act case is sometimes cause for concern. But this case is different from NFIB and King and the cases that have come before, because whatever the court does, this is wholly retrospective. It has nothing to do with what the Affordable Care Act means going forward. And it has the additional wonderful feature that Paul Clement and the Chamber of Commerce are supporting the Affordable Care Act.
Big fans of it.
So this, just a little bit of background. The major reform of the Affordable Care Act was to create exchanges in each state that would sell insurance, and the insurance would be available to people with pre-existing conditions, no bar on people with pre-existing conditions, and it couldn't be rated based on the health of the insured or various other characteristics. There was some concern that this was sort of an unknown world for insurance companies, and their ability to price that in this new market where they were taking on risks that they really wouldn't know because they didn't know the health status of the people who were buying their insurance, could lead them to price their insurance at very high levels. So the Act included a number of protections and incentives so that insurance companies would actually participate in this new venture without the risk that they would, especially in the initial years, price their insurance too low and end up with health care costs that were way in excess of the premiums that they received. And this case involves one of those programs. It's called the Risk Corridor Program, which was effective for the first 3 years of the ACA operated. and said that there would be some reimbursement to insurance companies on a scale if their payouts in terms of health benefits greatly exceeded the premiums they took in. And there was, on the flip side, an obligation of insurance companies that were in the reverse situation, where they had priced their insurance such that they ended up having a surplus, would have to give some money back to the federal government. And the rules of the road for this program changed a little bit. Initially, there was some indication from the administration and regulations that these payments would be available regardless of whether the payments back were less than the payments that were obligated to go out. And then subsequently, the administration changed position a bit and said, well, no, this is all about a program where there's going to be a balance, and we're not going to use any appropriated money to fund this program. So fast forward to December 2014, which was the first year that Obamacare was in effect. And I think it was Senator Cruz, wasn't it, who introduced the rider? I think maybe.
No, Ruby.
Okay.
Ruby, yeah.
There was a rider in the Senate to the appropriations bill that said none of the funds made available by this act from either the trust funds that fund health programs or transferred other accounts from the HHS authorization could be used to fund the risk corridor program. The state of play after the 3 years that the program played out was that $12 billion in payments were owed, and about only 4% of that amount, I think that's right, could be financed by the payments back in from insurance companies. And so not surprisingly, the insurance companies that thought they were going to get this money filed claims in the claims court under the Tucker Act, claiming that the federal government was nonetheless liable for these claims because of the statutory obligation to pay them, or maybe because they had an implied contract based on the statute, or maybe because they had a constitutional obligation and the failure to pay was a taking. And so the questions were sort of, the basic questions were twofold. Was there an obligation in the original Affordable Care Act to pay that was sort of unequivocal and not dependent on whether there was an appropriation? And then what about the effect of this appropriations rider? Did it somehow vitiate an obligation that might have existed before? And the Federal Circuit said, well, it's clear to us that there was an obligation to pay. It's shall in the Affordable Care Act, and that seems to set up an unconditional obligation to pay this money, even though there's not an appropriation. But we read this appropriations rider as essentially repealing that obligation, and therefore the federal government doesn't have to pay. Lots of insurance companies petitioned, 3 cases granted, and the question before the court, I think, will end up being both of those questions. The topside briefs have been filed, and they obviously focus on this question of repeal, the impact of the appropriations rider, and what does that mean. And I think, as folks know, repeals by implication are not favored generally, and there is some pretty good authority that in the appropriations rider context, courts are particularly skeptical that an appropriations rider somehow repeals some underlying obligation. And of course here, the appropriations rider is pretty specific. It doesn't say no federal funds. It says none of the funds made available by this act, which seems quite limited in terms of its effect. So lots of agreements on the fact that this appropriations rider doesn't make a difference, and that therefore the underlying obligation stands, and the court through the Tucker Act has an obligation to pay this money, make sure this money is paid by the federal government. And I think, sort of zooming out, lots of questions. It's not unusual for there to be statutory language that's mandatory, not necessarily accompanied by an appropriation, and the federal government taking the position that without an appropriation, we don't have an obligation to pay this money. The Anti-Deficiency Act, which people who've worked in the government is familiar with, makes it a crime actually to pay money that's not authorized by law. So often the General Accounting Office and other government agencies say you can't pay this money without an appropriation. On the other hand, there's a judgment fund created by statute that says there's a continuing appropriation when there's a judgment against the federal government. And so the big picture question is, if there's mandatory language saying the government shall pay, does that mean in almost every case, even if there's no appropriation, the person who's owed the money can go to a claims court, file a case, and get money? Obviously, a big concern for the federal government. On the other hand, the federal government increasingly relies on private parties to do things. If they rely on the fact that money is supposed to be available to undertake some obligation, should the government be able to welsh essentially based on the fact that turns out that there's not going to be an appropriation, or that some subsequent rider like this, while the program is sort of midway through, vitiates that obligation? So, an interesting question. It's especially interesting, I think, for Affordable Care Act watchers, because of course there was another question about payments under the Affordable Care Act. People may remember there was a case called House of Representatives against Burwell that dealt with the part of the Affordable Care Act that required the federal government to pay the co-pay payments for people who were getting subsidies under the act. And the House sued and said there's no appropriation for that, and therefore it can't be paid. And the president, when the Trump administration took power, suspended those obligations. So an interesting question about how this case, if it comes out in favor of the insurance companies, will affect those CSR obligations as well.
How much money remind me, is at stake in this case?
$12 billion.
$12 billion, okay. Paul, since you're arguing, anything you'd like to add to Andy's summary and why it matters and how you got so excited about enforcing the Affordable Care Act?
Well, see, this is a case, I think, that even somebody who might think that the Affordable Care Act either shouldn't have passed or might have been unconstitutional would nonetheless say, no, the government can't do this. I mean, this case, I think, really does come down to a question about whether the government can effectuate a $12 billion bait and switch. I mean, and I think Andy's right that I think the government will try to sort of relitigate the question they effectively lost in the federal circuit, which was the original promise sufficiently clear? But, the government's position is that no matter how clear their original promise to pay, and no matter how much people sort of relied on that promise to perform and incur substantial reliance costs, that unless there was appropriations for the first year of the promise, if the government just says, the Congress in 2011 thought it would be really good to have this program and make very clear promises to pay in 2014, but we're a different Congress. And we're just not going to appropriate any money. That, the government's position is then they don't have to pay. And, I mean, A, that seems kind of crazy to me. B, that seems like it's not in the government's own long-term best interest. Because, this is kind of like Lucy in the football. You only get to pull this move so many times. And if they successfully pull it here to the tune of $12 billion, who's going to ever rely on the government's promise that they're going to pay them down the road if it depends on a subsequent appropriations, especially because if you get into the nitty-gritty of this case, I mean, part of what's going on is that, by the time it rolls around to appropriate the funds, you now have the Republicans controlling the House of Representatives, and they still don't think much about the Affordable Care Act, and so their attitude is kind of like, hey, Obama administration, you got yourself into this fix. Where are you going to come up with the $12 billion? We're not going to appropriate it. And that's a dynamic that could play out, in any number of administrations and Congresses over time. And so I think, frankly, it would be a dangerous precedent for the government itself if it turns out that they just can't ever essentially make a promise that's enforceable that they will actually deliver on in subsequent appropriations years. Because again, without boring you about the details of this, there was no way, the government couldn't even figure out how much it owed people until the year after there was performance and everybody sort of tallied up what they paid out and what they took in. So this can't be the only context where it's really useful for the government to be able to represent to people, look, we need you to do certain things, and we need you to incur certain sort of reliance interests and the like. But don't worry, we're gonna pay for it, and we're the federal government, we're good for it, what could possibly go wrong? So I do think the precedent that will be set in this case is actually kind of going to be important generally for the federal government.
There's sort of a fun text versus legislative history aspect to the case, too, because as I said, the rider is actually quite limited, but the government's explanation for why it should be read as a prohibition on any federal funds being used to fund these payments is that there was a request to GAO for sort of an identification of what funds would be available, and the response was, these are the two possible sources. And so that's why the rider was drafted that way, and so you really should consider that and interpret this as a broad prohibition of federal funding. So it's sort of fun for the text versus legislative history.
Yeah, I think one or two justices, and I won't name names, but I think one or two justices were going to have some fun with the argument that, never mind the text, the reason we know the statute did what we wanted to do is that there was correspondence between the GAO and two congressional offices. I think that's going to be fun to watch.
Paul, I have a question about this. What would happen if, rather than doing what Congress did, they just revoked the promise? How would that be analyzed? Would that be analyzed as a matter of retroactivity at the threshold? Would it be a takings issue?
I think those are good questions, and I'm pretty confident that my clients would be saying it's some form of it's either a contract sort of Winstar, or it's a taking, and I'm pretty sure the government would be saying we don't owe you anything. And I will say one thing that's interesting about this case, just having gotten into it because I wasn't involved in the lower courts. This is not a case I've been thinking about for a long, long time. I would have thought that the answer to most of these questions had been settled in roughly 1804, or certainly after a bunch of people didn't pay for things after the Civil War. But the answers to these questions are not as clear from prior precedent as you might expect them to be.
Is the government trying to, I noticed just in leafing through the briefs that the government seemed to invoke at least some of the retroactivity case law. Do we think that that's the argument they're going to try to make here?
Well, they only invoked it defensively. So, one of the points that we've made is, whatever the rule generally, it's particularly problematic here because it was December 2014 when they were appropriating money for the 2015 appropriation cycle where they basically made clear that they weren't going to pay people for 2014. And I think where the government's position is more clear, and some of the cases that they have going in their favor is so in 1925, Congress says we're going to suspend the reenlistment bonus for service people, and then in 1928 somebody says I'd like my bonus because there's an old statute that says I get the bonus, and you just didn't appropriate enough funds for it in 26, 27, and 28. I mean, there I think the government's position at least says, no, it was clear enough from the appropriations that we were no longer doing that. That's a reasonable position, but I think it's a much, much harder position to sell to say, yeah, we wanted you to perform in 2014, and you couldn't possibly have known that we weren't going to pay you in December, but nonetheless, we don't owe you a penny. That's pretty tough.
Where would the money come from if the government is required to pay it?
The judgment fund.
Oh, they have okay. all right.
There's this continuing appropriation for judgments.
I see, okay.
I mean, in fairness, so, which is to say, from your wallet and your wallet and your wallet. The judgment fund is just not like a big pile of cash in Beverly Hills. I mean, it would have to be. It's a mandatory appropriation. So if something comes out of the judgment fund, it's not discretion. Congress can't pull this when it comes to the judgment fund. So they can't say, yeah, we owe hundreds of litigants millions and billions of dollars, but we're just not going to do anything with the judgment fund. So that's.
And it has $12 billion in it right now?
It has the capacity to get $12 billion in it through the mechanism of your wallet.
Oh,
yeah.
It is there's no ceiling on it, but it obviously
So it automatically increases to meet the needs of your clients.
Yes, it's refunded magically every April 15th.
The sympathy for Paul's position just dissipated throughout the room. The Clement tax increase of 2020 is not too far away.
Interesting full disclosure.
Talking about government obligations, as a transition. Where we have another major case. This one also involves, I think, a lot of individuals' investments around the country, and also the status of Puerto Rico. That's the Aurelius Investment versus Puerto Rico and related cases, and we're excited for Carter to walk us through them.
So I realize that I am the last thing between you and lunch, so I will try to be at least somewhat brief, but indulge me for 2 seconds to make a comment on the previous case, because the sense of deja vu all over again. I argued the Rama Navajo case against the United States several years ago, and in that case, the United States government entered into contracts with all of the Native Americans to provide services on the reservations. They offloaded U.S. responsibilities to them. All the Native American groups did all of this work. And then the federal government came back and said, oh, well, we don't have enough money to pay you all, so we're just going to pay you on a pro rata basis, but you should be perfectly satisfied with that. And the Court of Appeals upheld that, saying, oh yeah, okay, that works. And so I took it to the Supreme Court, and I thought to myself, this is a pretty remarkable proposition, right? I can go out and enter into all the contracts in the world, and as soon as I run out of money, I just say, well, I'd love to pay you, but I don't have any money. It seemed to me a pretty counterintuitive contract principle. I won that case 5-4, so it always scares me when anytime you litigate against the United States government, especially when it's got a lot of money at it, you do have to worry at least a little bit, and so it's I don't put that out of mind. Now, with respect to the Puerto Rican case, first of all, the plaintiffs there are significantly less sympathetic than Paul's.
Than insurance companies.
Than insurance
They're less
companies.
sympathetic than insurance companies.
So these are hedge fund vulture investors who have accumulated a significant amount of bonds, a large sum of bonds, billions and billions of dollars of these bonds from Puerto Rico. Puerto Rico obviously went into extraordinarily hard economic times, and candidly continue to be on hard economic times. And unfortunately for Puerto Rico, they did not have the benefit of the bankruptcy code to allow them to intervene in some meaningful way to relieve those debts. But fortunately for them, Congress did in fact pass a statute in which it created a special board to help essentially Puerto Rico to reorganize its debt situation. And it appointed the members of the board in a very specific way that Congress identified, which is that the president could, without using the advice and consent of the Senate, adopt, pick names provided to him by the majority leader, the minority leader of the House and the Senate, and et cetera, and then he could pick his own person as well. And it didn't have to go through confirmation process. And so that was the board, and it was put in place. And it did what a bankruptcy court would ordinarily do in order to try to reconcile all of these obligations of Puerto Rico. And candidly did it in a way that was much more beneficial to pensioners of Puerto Rico than it would be to the creditors of Puerto Rico, which is why the creditors are outraged by this particular situation. I think the pensioners are either being covered 100% or some 90-some% of what the obligations would be for them, whereas a lot of the creditors are going to end up with literally pennies on the dollar in terms of the way this gets allocated. The clever theory that the hedge funds came up with for why this would be impermissible was the notion that they hadn't been properly appointed, that the members of this board were not properly appointed under the Appointments Clause of Article 1, and that as a consequence of that, all of their actions are illegal, and therefore you got to start all over again with properly appointed individuals. The case goes to the district court, and then in the First Circuit said, yeah, that's right. You have to abide by the Appointments Clause. It does apply in Puerto Rico, but there's a de facto officer exception to the principle. It says that under certain circumstances, even if you haven't been properly appointed, you don't have to start fresh. You just have to, you can ratify in some respects those appointments after the fact and get around the problem. The petitioners took that case to the Supreme Court, and the Supreme Court granted certiorari.
you know, the court has been very concerned about appointments clause issues. You know, the SEC case from a term or two ago, the court said that, you know, administrative law judges had to be appointed in a particular way. And you know, they didn't adopt a de facto rule for that situation. They just basically said, look, if you're going to go back, if that's what you're going to do, you're going to have to appoint brand new administrative law judges, and you're going to have to start over. That's one thing when you're talking about the number of SEC cases that have been decided by administrative law judges. You can probably count that in maybe not on two hands, but you know, two hands and two feet will probably get you. I mean, the retroactive effect of that was not all that significant. Here you're talking about reorganizing literally hundreds of billions of dollars of the Puerto Rican economy, and if all of that's now been undone, you will obviously create an extraordinary disruption to an economy that's already suffering badly enough. So that's how the First Circuit got out of it. Candidly, the way this is all going to turn out is going to have nothing to do with the Appointments Clause. It's going to have to do with Article 4, which has a provision that allows Congress to make all needful rules covering territories and possessions. And obviously, Puerto Rico is a territory of the United States and has been recognized as a matter that Congress has very, very broad discretion. It doesn't have enough discretion to avoid the presentment clause of Article 1, but generally speaking, once you get out of that, Congress can pretty much structure Puerto Rico however it wants. And so in this board, which it's created, it sort of sits somewhere between the federal government and the state government in the sense that it has authority to tell all of or the Puerto Rican government, to tell all the Puerto Rican government officials what they can and cannot do, which is pretty cool power to have, I would guess. But it's not part of the federal government in that sense, or at least it was designed not to be part of the federal government under those circumstances. So are these officers of the United States, you know, if this were in some other circumstance, my guess is the answer would be decidedly yes. But because it's Puerto Rico, and because Congress has much broader authority under Article 4 to deal with Puerto Rico however it wants, it can structure this governmental scheme in any way that it wants. And I don't see any likelihood that the court's going to revisit that. Now, just asked me to, you know, what does this mean for the insular cases in which you know, Congress and the federal government have, over the years, done some extraordinarily negative things to Puerto Rico? And the answer is I don't think it's going to have anything to do with it, because the court's not going to revisit those issues, other than perhaps in passing it to make an apology. But other than that, because they've done that before in some situation, but I don't think they're even going to do that here. I think they're just going to say Congress can do what it wants in this context, particularly when the situation would otherwise be pretty disastrous. And I don't think the court's going to be, you know, I mean, they're interested in the Appointments Clause, but I don't think they're going to be interested enough to reach out to get at that issue in this particular context. So.
No, thanks, Ray. Yeah, I think that I was interested in that only because the legal status of Puerto Rico is it's something certainly that the Puerto Rican government is very aware of, and the Supreme Court has had a few opportunities in recent years to comment on that, and in every case has really diminished Puerto Rico's standing as anything near a state. It's really treated legally essentially as a colony and has no power whatever over its own affairs other than what Congress chooses to give it. And so the Puerto Rican government tends to bring that up a lot in its briefs, and I think some of the other amicus briefs also discuss the unusual legal status of Puerto Rico in this case. But and because if it was a state and it had the same economic situation and the same issue with its bonds, its remedies would be very different under the bankruptcy code and sovereign immunity and elsewhere. So we are just about done, but first I do want to see if there are any questions we have about the business cases this term.
I have to say, the thing that's the most disappointing is that when I originally got put on this panel, I was thinking to myself, oh, it must be punitive damages cases, class action cases, implied preemption cases, implied dormant commerce clause, all the things that are the grist for the business law mill, and we had none of that stuff. And we don't even have any interesting antitrust cases or interesting Securities Act cases. It's really
not even arbitration.
It's miserable.
Well, it's time well spent, isn't it? But let's have your question.
Sorry, you just a while ago you said there was something fun involving something called like a GAO about, like?
GAO.
GAO.
Government Accountability
Yes,
Office.
yes, I had no idea what you were talking about. I just had no idea. And so I was hoping.
So just this
By the
sort
way,
of
the
interesting.
concept of fun and the GAO
Yeah.
in the same sentence is unbelievable by its nature.
Grimmest-looking building in Washington. No, the fun thing is this text versus legislative history. So the legislative history is this correspondence between Hill offices and the GAO, which is sort of the government paymaster. And so the justification for reading the narrow language of the appropriations rider broadly is that this correspondence told told Senator Rubio's staff, essentially, that these were the only two sources of federal funds. So you should therefore interpret this appropriations rider, the government says, to bar all federal funds, even though it only targets these two sources.
Yeah, and just the broader point there for students is that in terms of legal method, some justices prefer only to look at either exclusively or almost exclusively at the text of the statute itself, and anything extraneous, even if it's related to the way the law was passed, like this correspondence between officials, they don't want to see it. They think all that matters is the actual words of the statute. Other justices are more open to looking at other material that might inform their understanding of the statute. And so, because this is one of the really methodological issues that we see at the Supreme Court, Andy is excited to see how it may turn out.
Find your fun where you can.
That's right.
Take different cases where you have a lot more fun.
All right, well, Sammy's going to have a public service announcement in a moment, but before that, I wanted to again say that, these fellows are some of the best advocates at the Supreme Court. You heard them make a great meal out of some leftover grist today. I'd encourage you to go to oea.org and listen to them argue. All four of them have many oral arguments before the Supreme Court that any of you can listen to without, and there's no copyright. Am I right? That you don't have to pay to hear them argue and interact with the justices who throw them questions. So a big round of applause, please, for us.
Just a few announcements, so please stay seated. So we have CLE credits for those who want them. Please talk to Ms. Allie Trevette at the check-in table before you leave. We're also selling Ms. Biskupic's book on the life and turbulent times of Chief Justice John Roberts, and she's agreed. And she's agreed to sign them throughout the day. Don't interrupt her during a panel, but between on the breaks. And then so for lunch, we have 3 panels, advocacy panel in 124 and judges panel in 127. They're down this hallway. And then we have Chief Justice Roberts in room 133, which is down that hallway. We have people directing you out there.
He's in that room right
No, sorry. The panel on Chief Justice Roberts. And then can we please let our panelists leave the room first, that way they can eat their lunch while you all are getting your lunch, to allow them to be able to talk during lunch instead of trying to eat and talk. So please stay seated if you're in the back, let the panelists go, and then you can leave once they...
This must be a full employment act to make this crazy. There's no way.
No,